Welcome to Looking at Legal Stuff. Today we have 9 hearings, including a nearly 3-hour trial in the divorce of a couple where mom claims that dad is behind on child support and daycare payments, and she says he quit his high-paying job with overtime for a low-paying job as a maintenance man in an attempt to reduce his child support. She says he has always made work his priority, and she's effectively been a single parent since the day their child was born. In fact, she says dad's never even spent longer than 8 hours alone with him, and he even refused to show up for his son at the emergency room. What will Dad have to say about these and many other accusations? Let's find out. In the months prior to the start of this video, this couple had a mandatory settlement conference where it says they were unable to come to an agreement, but we later find out that Dad was actually a no-show. That means they had to set a trial to resolve the case. We join them 3 weeks before their trial starts, and we'll be watching 3 pretrial management/motions hearings before the trial begins, and then several contempt hearings afterwards.
And on number 15, Geese and Geese, I see that you recused after the MSC that Mr. Geese didn't appear at. I didn't know if you were going to keep that recusal on file and if we needed to set that pretrial over.
I noticed that myself, and I couldn't remember what the recusal was for. I went back, found it, and I again wasn't sure if that was the one that I had with you where there was a no-show, and it sounds like that's your recollection. I also see that it is on next week for a motion at 9 a.m.
So and that was due to your recusal. The clerks kicked that out and said it had to be on the A docket. So I wasn't sure what your thoughts were on today.
My thoughts are, let's pass readiness over. Since that recusal is still in the file, we'll pass it pretrial 2 next Tuesday the 5th at 9 a.m. and both of those matters can be heard at the same time.
Very good. Thank you, Judge.
All right, thank you.
All right. The final matter is is it Gisa?
I think we usually say Geese. It's
all Geese v. Geese. Cause number 22-3-00285-08. Ms. Bliss is present. Do we have Jacob Geese present? Yes. Okay. All right. Counsel, go ahead.
Thank you, Your Honor. For the record, Carly Bliss on behalf of the petitioner and moving party, namely Natasha Geese. This matters before the court on my client's motion to request father submit to a hair follicle test and suspend visitation pending a clean hair follicle test. My client outlines her concerns within her motion, looking primarily to the temporary parenting plan entered this time last year. There was 191 findings for substance abuse for father. He was required to undergo an evaluation. Upon receiving the results of that evaluation, it indicated father was not recommended any treatment due to actively being in recovery and not having any recent relapses. My client provides for the court within her declaration some concerning statements, not only made by the mother of Mr. Geis's other child, but the fact that there are current CPS investigations relating primarily to suspected drug use. My client provides for the court that she is very concerned. This is a tender age child. Ezekiel just turned 2 years old, and frankly is incapable of protecting himself against any suspected drug use. Within the allegations to CPS are Mr. Geese not only leaving his children alone while he goes to the bar, and mind you, his oldest child is 8 years old, so potentially leaving an 8 and a 2-year-old alone to fend for themselves while he's at the bar. There's some admitted cohabitation and being around drug use. Mr. Geese specifically said he's residing with his mother, and there are known methamphetamine and cocaine users within the home actively doing drugs in front of him. Again, this is also concerning, again, given the age of the children who are residing with him, granted on day visits, but unsupervised within his home where there is this active use, admittedly by Mr. Geese. There are some significant concerns. My client's simply asking the court to order Mr. Geese comply with a hair follicle. Again, given the recommendations of the evaluation this time last year, there was no specific language for hair follicle testing or UA testing, which we typically see when we have those 191 findings, especially when it relates to substance abuse. But given the active recovery and no recent relapses where Mr. Geese was this time last year, my client didn't request that language as she was hoping hoping that he was on the up and up. Given the fact that there are these concerns, and I don't believe in Mr. Geese's filings that there was any objection to completing a hair follicle if the court ordered one. So that's our request today. I will note in Mr. Geese's pleadings that he provided for the court, he provided some drug testing. If the court were to look at that drug testing, one of which, the very first one, shows that it was an oral swab. The court knows, and I'm sure the court is aware, with oral swabbing, that only goes back 48 hours. And if you look at the initial results, he tested positive. And then it says later it was concluded that it was negative. So there's some concerns there, not only the length of time that the testing covers, which is 48 hours, but the fact that the initial testing deemed positive. So there's some concerns there. If you look at his, it looks like some UAs that he provided prior to his employment, he tested positive for marijuana. Again, for somebody who has an addiction history, someone who is supposed to be refraining from everything, alcohol, marijuana, illegal substances, even testing positive for marijuana is telling that there has been a relapse of some sort with Mr. Geese. Given the tender age of the child, given the history of substance use and abuse, we are asking that the hair follicle test be ordered, that he immediately comply with that today, and that visitation be suspended pending a clean follicle test.
All right, sir, go ahead. Anything?
So I'm willing to submit any required testing that's asked of me, and using marijuana is not illegal. And I talked to DCS, which DCS did the mouth swab, and I even asked them why it came up positive for what it said positive and then negative. And she said that she doesn't understand why it came up positive and then negative, but they don't look at it that it came up positive at all. And they're closing out the case, the DCS is. And I asked her if they would be able to get me the report so that way I could submit it before the courts today. And she said that she wouldn't have it in time for me to be able to submit it.
All right, so sounds like you're not objecting to do this. Ms. Bliss, what panel are you asking for?
Usually I request the 9 or 10 panel just because it does include all of the potential amphetamines. It does include marijuana, and it's not as costly as the 17 panel. So I think the 9, or I can't recall if it's a 9 or a 10 panel, but that's typically the one that we usually request.
Can you check to see, because I was going to include it in the order. I want to, so that the testing agency knows what it is that they're testing for.
Let me see.
I'm not in any financial disposition to be able to afford that, by the way.
I believe it's a 10 panel, Your Honor, is what I just looked it up, and that's usually what we request.
Okay, so.
And if Your Honor looks at my order, my client would be advancing the fees for that testing. And if it does come up positive, then Mr. Geese would be responsible for reimbursing, but cost should not be a prohibiting factor in this matter.
So I am going to go ahead and order the request. I'm going to include in here 10 panel. I am striking the blood test. I think that's too invasive. I don't think that's appropriate. And it will be up to the mother. Are you also wanting, because if the suspect is it alcohol intoxication? Is that what you're thinking?
That his current uses is, I mean, that's one of them. Obviously that coupled with his exposure to methamphetamine and cocaine usage within his home.
I do want to go ahead and have a test done now. Basically get a bottom line. All right, so here's what I'm going to do. I am going to go ahead and order the 10 panel hair follicle test well, I'm going to sign the order, but also I've written in the father is to do a hair follicle test by 12/5/23. So today he is not to color or cut his hair until done. And then I want to set this back on. And how quickly do they get those results?
Lately, I've been seeing 3 or 4 days post-test is usually when we get those back.
Okay.
So ideally, we'd have it back before next Tuesday, or if that was what Your Honor was anticipating.
That's what I want to have this order reviewed next Tuesday. So let's do an initial hair follicle test. And the mother will pay for it at this point. That can be argued later. But then I'm going to set a hearing for next Tuesday at 9 o'clock. And that way the results can be seen, because it'll go back 90 days. So you're going to know if he's been using or not. And so I'm going to add a paragraph 4. This order shall be reviewed. That would be December 12, 23 at 9 a.m. to determine if it should remain in place. All right, so again, I made the change of adding or 10 panel hair follicle test under paragraph 2. I did strike the word blood test, and I did add the father is to do a hair follicle test by December 5/23, is not to color or cut his hair until done. And then I added a paragraph 4. This order shall be reviewed December 12, 23 at 9 a.m. to determine if it should remain in place. Okay.
Very good.
All right. Sir, are you okay to put approved via Zoom on this order?
So I'm going to take a hair follicle today.
Correct.
Okay.
Okay.
When
so
do I, when do I get
hair?
right?
So
When do I get the,
be in contact with Miss Bliss, and
Okay.
I'm assuming Miss Bliss, you'll give him directions as to where he needs to go.
Correct. I can
Okay.
do that.
so I work in Battleground, Washington. I'm at work right now. Am I going to have to leave work to go do this?
I can
Where-
look for a location near Battleground so he doesn't have to travel all the way up to Kelso Longview.
Okay. Okay. So I would just stay in contact with Miss Bliss and get that worked out. Okay.
Okay.
All right.
And Judge, I didn't see on the docket, this was also supposed to be pre-trial. It was on last week on Judge Fassett's docket, but she had recused because she had heard the MSC. I just am concerned if we don't just deal with the procedural issue of pre-trial, and when we get to trial, the court may, strike it for not completing that.
So I did not have it on for that purpose, but let me ask the clerk any problems with just adding that? Okay, let's go ahead and address that. When is your trial date?
I think it's set for the week of the 19th or the 18th.
Let's see, December 18 is when the non-jury trial is set. All right, so excuse me, you do have a trial December 18. I'm assuming via Zoom, is that correct?
Correct.
So that'll be via Zoom. And sir, you understand that if you go to the Cowlitz County Superior Court website, it talks about having a Zoom trial, and it tells you the process if you have evidence such as documents that you want the judge to see, how it is you go through the process to get those to the judge. Okay.
Okay. All right.
Okay. All right. And that that will be your day to present any evidence, whether it's verbal testimony or documents. So make sure to get on there right away and make sure that you timely get everything sent and provide it to the judge, okay? And it's always
Okay.
good to do bench copies just so they have that. And then you need to make sure to also, whatever you send, you need to provide to Miss Bliss, okay?
Right. Yeah.
Okay. Miss Bliss, anything I missed?
Nope, I have no concerns, just Mr. Geese, if you can just be sure to provide me any witnesses that may be testifying at trial as well, in addition to
Okay.
yourself.
Do you have any witnesses you think you will be calling?
I don't know what I need a witness to in this situation exactly.
Okay. Well, why don't you think about it for a couple days, see if there are any witnesses that you want to have appear and talk about you and what, you know, kind of whatever it is that you want to present to the court. If you don't, that's okay. But if you do have someone, then Ms. Bliss also has a right to their name, address, and phone number. Okay.
Right. And my opinion on the situation is that we're just getting a divorce. It's not a criminal matter or anything along those lines. And I don't necessarily feel like that somebody needs to stand up in my disposition, because that's what we're doing in this case is just nullifying the marriage. And so I just don't understand.
That's up to you. And whether you want to maybe consult with Cowlitz-Wakayakum Legal Aid, just to make sure you're doing everything, because that is your day of trial. And you're right, it's not a criminal trial, but it's still involving you and your life. So you want to make sure that you look at it as important, and which I know you do, but that will be your day to present evidence. Okay.
I understand. Thank you.
Okay. All right. All right.
I have a question pertaining to the hair follicle, and it's going to, as it shows negative results. Can we nullify any further actions on drug testing me, because this is a consistent and persistent harassment against myself, because this has been ongoing since the beginning of this
Listen
divorce.
to me for a minute. That's why I put it on next Tuesday to
Okay.
review it, to see whether or not the order is going to continue.
Okay.
Okay. If it comes up negative, then it may be that I'm assuming Judge Evans will be back. He may decide that it doesn't need to stay in place. I don't know. I can't make that decision until everything's done. But that's why I put it on next Tuesday. Okay.
Thank you.
Okay. All right.
Thank you, Judge.
All right. That concludes.
Mr. Zandy is here representing Natasha Geis, and Mr. Jacob Geis. I see him here also. Can you hear me, Mr.? And you correct me on the pronunciation, please.
I don't know what the correct pronunciation of it is, but I think Geis is great.
Okay, we'll go with that. Sounds good. All right, so we're here for a review hearing, and let me just get my notes up related to. Looks like we have the trial coming up the week of the 18th, and readiness is today at 11:30. Is that what I understand? And we're also here to review results from the 10-panel follicle test, and update for witnesses and contact information and the like. So that's kind of what I'm expecting, and you all may have different expectations, so I'll hear from each of you.
And again, Your Honor, filling in for Ms. Bliss, who's over at the Hall of Justice on a different matter this morning. She gave me clear notes. We discussed about it this morning. My understanding is that, yes, you are correct. There is trial next week. And today's review was just to look at the hair follicle screen from Mr. Geis, sorry. And those came back clean, and visitation will resume. And we're ready to go to trial. I don't think there's any further issues that need to be resolved today, at least in my discussions with Ms. Bliss and the notes that she provided today.
Okay, thank you, Mr. Zandy. Mr. Geis?
Well, I'd like the opportunity to be able to speak up on the matter of even the hair follicle in itself. Since the beginning of the divorce process and the custody hearing, I've gone to a treatment facility and had a drug and alcohol analysis done, and I was clean at that point in time. At the beginning of all this, I've submitted multiple drug tests, all being clean, except for I had submitted 2 that were positive for marijuana, which doesn't make me a criminal. I've never used any drugs in front of my children. I am a good father, and I love my children a lot. and I'm just being named as a bad person, and all for what? Because of hard feelings in a situation. And I I don't quite understand why it's having to come to such a lengthy process, and just for me to be able to be a father. I understand that a relationship failed out of all of this, but it doesn't mean that I'm a bad person or a bad father. My children are very important to me. And so the accusations, nameless accusations, them not being true, and me having to defend myself for what reason. And I'm just disturbed by how it's a revolving door of me constantly having to say the same thing over and over again, where I'm not the person that I'm being called out to be. And it's a kind of a painful process.
No doubt. I think any divorce proceeding is very painful, and it's disconcerting in a lot of different ways. So it sounds like the hair follicle test was taken, so I appreciate that. It came back, it's clean, there's no issues there. And the issues that remain in the case are going to be resolved at the trial, which is coming up. We'll find out today, the specific date and time, today at 11:30. So that's where much of this can be aired, and hopefully some clarity can be granted to the situation, and the parties can move forward. So I appreciate taking care of that hair follicle test, and any of those issues that are concerning. Obviously, those can be raised at the trial, and greater clarity can be provided. So with that said, I'll just invite both parties to be on the readiness docket today at 11:30, so you know the specific date and time that the trial will be set for next week. You can all be prepared and ready to go. Any
Very
final?
well. Thank you, Your Honor.
Okay.
Thank you.
Great. Thank you, Mr. All right. Good morning, all. Let me just confirm with our Madam Clerk that we're on the record before we proceed.
You were on the record, Your Honor.
Perfect. Thanks. Okay, I'm Judge Evans. We're here today in the matter of Natasha, and I think the correct pronunciation is it Geis?
I believe so.
Okay, Geis, we'll go with that. Great. And I see Ms. Bliss is here with Ms. Geis, assumedly. And then
Yes.
I see Mr. Jacob Geis is present. Mr. Geis, can you hear me okay?
Yes, sir.
Okay, great. Joining us also is Ms. Looney. She represents the state. She's present. And Ms. Looney, can you hear me all right?
Yeah, good morning, Your Honor.
Good morning. All right, the cause number that we're working with today is 223-00285-08. I believe the issues to be addressed today are property distribution and debt distribution, parenting plan, child support, and fees and costs. So Mr. Geis, do you agree with that, or are there any other issues that you're planning on addressing today?
I believe that's all that we need to go over.
Okay. All right. So we're here today for a trial, and I know that Ms. Looney sometimes will ask to maybe go first and maybe be excused, and I'm not sure what her position is, so I just wanted to touch base with her to see where you're at.
Yes, Your Honor, the state's only interest as to child support in this matter is for medical. So our only request is that it be noted in the final order that the child is on state medical through the mother.
Okay. All right. Thank you, Ms. Looney. Ms. Bliss, any comments related to that?
No, Judge, upon seeing Ms. Looney on the call today, I realized that I did not include that in my final child support order, but I have no objection to including that language, obviously, that is appropriate.
Okay, great. And Mr. Geis, any comments you have related to that?
I'm just curious what expectations are to be held to the situation.
When you say expectations, tell me what you're thinking there.
I have another child and he's on state medical as well, so I'm not quite sure what the disposition of the situation would be.
Ms. Looney, can you just share the state's position, what you're hoping to have added or included in the orders?
Your Honor, we are only asking to just have it noted that the child is receiving state medical. We're not addressing any other children, just the children shared between these two parties. So if Mr. Geis has questions about his other child, he would need to contact DCS about that.
Okay, so
all right.
Yeah, go ahead, Mr. Geis.
I don't have anything else to say. I wasn't quite sure.
Yeah, and it's fine, just questions to clarify and the. So Ms. Linney, so as far as you're just asking for the orders just to simply make a notation that the child here is being covered by state medical insurance through the mother.
Yes, Your Honor.
All right. Any questions on that, Mr. Geis? Any further questions?
Just as I previously stated, I didn't know exactly what the concerns or what's to be addressed in the situation. I think that she just verbalized that it's just to be noted and documented.
That's my understanding. And Ms. Looney, is there any fallout from that if it's noted or documented that the child's on state medical?
No, Your Honor, it's just to be sure that the order includes that the child is receiving state medical. That way it is clear in the future that mom is fulfilling her obligation for providing medical insurance, which both parents are obligated to do. It just shows that she is doing that because she does not have other insurance available.
Okay. All right. Thank you. Ms. Bliss, Mr. Geis, any further comments related to the state's position?
I don't have anything further, excuse me, and I don't have any objection to Ms. Lindy being excused.
Okay. And Mr. Geis, any further questions or issues?
I believe that matters. Yes, I agree to the situation. I'm not exactly sure what to say.
Okay, yeah, that's fine. Great. All right, Ms. Looney, thank you for being here today. It sounds like there's no opposition to including that language in the order, so that'll happen. And if you want to leave, you're free to do so.
Thank you, Your Honor.
All right. All right. So with regard to the trial today, just a little bit about procedure and expectations. Here, the petitioner is see as Ms. Geis, represented by Ms. Bliss. So generally, the petitioner goes first in the trial in which they call witnesses to establish a factual basis for what they're asking for. So they'll be calling witnesses, and with each witness that goes, that's called, Ms. Bliss will ask the series of questions first, and then Mr. Geis, you'll have an opportunity to ask that same witness questions under cross-examination. And then after you've finished, then Ms. Bliss will have some more opportunities to ask questions of that same witness. And then you would then have an additional opportunity to ask questions of that witness on what they call recross examination. So it's kind of like a funnel in that the questions start off fairly broad with Ms. Bliss going first and then you going next. And then Ms. Bliss goes their second shot at that witness, and it's a little more narrow. And then the questions that you ask would also be kind of limited to the scope of the questions on that second round of questioning of that particular witness. So with each witness, that once she's called all of her witnesses, then Mr. Geis, you'd be entitled to call your own witnesses, including yourself. If you do call yourself, we just allow you to provide a narrative. You don't have to like ask yourself a question and then answer that same question in kind of that stilted manner. We don't do that. And then as far as any exhibits or documentary or documents that you want to have admitted or have the court considered, we should have had those already admitted or at least provided to the clerk. I have some from Ms. Bliss, and I just want to touch base with Mr. Geis if you had any documents that you're hoping the court to see or review.
Not necessarily. I've gone over what Ms. Bliss has put together, and I would like to be able to discuss some of it on my opposition to it. Other than that, I don't know. I don't have anything that I would have filed necessarily in the case.
Okay. Yeah, you'll certainly have opportunity to question and address those particular documents that Ms. Bliss has provided. And I have a copy of all of them, so I'll be able to look at what you're talking about. And then so then after you've called your witnesses, Mr. Geis, then Ms. Bliss may call what they call rebuttal witnesses. And you would also have opportunity to ask those same witnesses questions. So after everybody's presented their evidence through testimony or documents, then we go to closing argument. That's where each party kind of summarizes their argument based on the facts that are presented and say, this is why I should win and this is why I should get what I want. And then I'll take the case. And if I usually like to take some time to deliberate and reconsider the information that I've heard. And generally, depending on the timeframes, I would come back today and give you an oral decision. If it's going to take a little bit longer, I'll let you know and we'll set a date for me to give you the decision. Then once the oral decision has been given, then a summary of that oral decision would be put into writing, and we would probably set a date for a presentation in the future. So that's kind of an overview of the day. Be aware that if there's objections, feel free to make objections. I'll rule on those as we go through things. And if an objection is made, just ask everybody just pause and allow me to address that issue, and then we can move on. Other than that, I'll just turn to the parties to see if you have any preliminary issues that need to be addressed. Ms. Bliss, do you have any preliminary issues?
I do not, Judge. We're ready to proceed.
Okay. Mr. Geist, do you have any preliminary issues before we get started?
I define preliminary issues.
Sure. Sometimes there may be for example, it would be some type of request prior to the trial getting started that may impact the trial. It may be a limitation on some evidence, or a request that certain witnesses be taken out of order, or a witness not be allowed to talk about X, Y, or Z, or anything that would kind of affect kind of the future trial, or the trial that's about to begin. So anything that may impact that was kind of a preliminary issue.
My only concern throughout this whole process is accusations made against myself being relevant to narcotic use, and there being no factual basis, and then me proving myself innocent in the situation, following that. And is my question is this going to be an ongoing matter where, I've had to prove myself time and time again, and then where's the evidence to the situation, kind of a deal?
All right, so it sounds like you're concerned about allegations related to narcotics use made by others, and you're concerned about substantiation of those allegations. And so usually the way we deal with that type of information is that if there's testimony presented, persons can testify to what they've observed or seen or know. If you feel that they don't have a basis for that knowledge, or there's some concern, you can lodge an objection and state why you feel that's objectionable and should not come into evidence. And then I'd rule on that. And if the ruling's in your favor, then that person wouldn't be able to testify of that particular issue, or that limited scope. If I rule against your objection, that means that I'd allow the testimony to come in. So oftentimes during trials, there's testimony that comes in that neither side particularly likes, and is not necessarily helpful to their case. Sometimes they may object to that on that basis. That's not a valid objection. It has to be on the basis of that there's not personal knowledge of that information. So you're certainly welcome to raise those objections as they come about during the trial, and we can rule on them as we go forward. I think it's going to be context sensitive, so I probably need to hear that information as it comes up during the trial. I don't think I can give a preliminary ruling on that at this point.
All right. Yeah, I just know that when it comes down to these kind of things, unless there's actual proof to a situation, it's more or less a he said, she said. And you can't really, not you personally, but you can't really make a judgment based off of someone said something. What's come down to is a defamation against myself and other people involved, or other people mentioned in the situation.
Yeah, and it's not uncommon in jury or in trials to have he said, she said situations. That's not uncommon. It's very common, and that's where the court makes credibility determinations and weighs the evidence that's presented. So it's not uncommon that there's he said, she said, she said. Pardon me. So with that understanding, I think we'll proceed forward. If there's no other preliminary issues, we'll hear opening statement from Ms. Bliss, then we'll turn the time to Mr. Geis if you'd like to present opening statement, and then we'll turn the time to Ms. Bliss for the calling of her first witness. So Ms. Bliss, opening.
Thank you, Your Honor. I'll keep it brief. The issues before the court today are very minimal. The court is aware I do represent Ms. Geis in this matter, who is the petitioner and moving party. Your Honor kind of outlined the issues being presented today, the issues relating to asset and debt distribution, the parenting plan of young Ezekiel, who you'll hear referred to as Zeke throughout the course of this trial, child support for Zeke, and the issue of attorney's fees. I did provide a trial aid in this matter, and I trust your honors had the opportunity to kind of get an overview, at least of our position. So at this point, I would finish my opening statement with the proposals that we've provided to the court are fair and equitable as it relates to the asset and debt distribution. The parenting plan and child support for Zeke are in his best interest. Attorney's fees, you'll hear testimony from my client today, are warranted in this case, given the significant hurdles that we've had to overcome with Mr. Geese, on top of my client paying for this entire matter to be proceeding. So we are asking the court to enter our orders after you hear some testimony today, and I'll kind of reserve the rest of any statements or arguments for later in the trial.
Okay, thanks. Mr. Geisen, any opening statement you'd like to provide?
I would like to just say that given the circumstances of the divorce, I understand that there's hurt feelings involved, but the person that really matters in all of this is Ezekiel. I understand that the dissolution of her marriage is part of the topic, but another part of the topic is that there's a child involved in the situation, and how he feels really matters in all of this, and I hope the outcome's in his favor.
All right, thank you, Mr. Geis. All right, Ms. Bliss, if you'd like to call your first witness.
Thank you, Your Honor. I'd like to call my client Natasha Geese.
All right, ma'am, if you please raise your right hand, I'll administer the oath. Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Will you please state your full name and spell your last name?
Natasha Daniel Marie Geis.
Thank you.
Oh, Giese.
Perfect. Thank you. Go ahead, Ms. Bliss.
Thank you, Judge. Natasha, you were the named petitioner of this action, is that correct?
Yes.
And are you a resident of the state of Washington?
Yes.
And where do you currently reside? What city?
Kelso.
Okay. And is it your position that Washington has jurisdiction over your marriage
Yes.
and of your dissolution?
Yes.
When were you married?
August 31st.
Okay. And was that in 2019?
Yes.
Okay. And when did you and Mr. Geis separate for a final time?
March 12th, 2022.
Okay. And is she coming through? Is her audio coming through?
Kind of. It's fairly clear, but there's some things that were kind of trails off, like that 2020. I wasn't quite sure of the data separation. It wasn't as clear as I'd like it to be.
I suspected that. So just make sure that you're, obviously the mic is right next to us, but make sure you don't know. We just got to make sure that the record is very clear. So will you say again when you and Mr. Geis separated for a while?
March 12th, 2022.
Very good. And what happened on the state?
The exact day we had a disagreement over a situation that involved Elijah and Jacob and myself as Zeke, and I asked him to leave.
Okay. And we haven't discussed Elijah yet. Who is Elijah?
Elijah's my stepson.
Okay. And that's Mr. Geis's other child.
Yes.
Okay. And so after this incident, you asked Mr. Geis to leave, and then you filed for divorce.
Yes.
Okay. Was Mr. Geis personally served with the petition for divorce?
Yes.
Okay. And was that in August of 2022?
Yes.
Okay. During the course of your marriage with Mr. Geis, you obtained a few assets. Is that fair to say?
Yes.
Okay. So let's talk about that. What vehicle do you drive?
The 2022 Tucson.
Okay. And that was acquired during the marriage?
Yes.
Okay. And what would you say the condition of this vehicle is?
Yeah.
Okay. And do you have a rough guesstimate of what you think this vehicle is worth?
25,000.
Okay. Do you recall?
Just this, Ms. Geis' voice was not terribly clear on the value. I'm wondering if she could maybe change her position, or maybe move closer to the speaker, like shift her chair down a little bit further so I could hear a little better.
There we go. We'll try that again. Thanks, Judge. Can you say again what you believe the rough value of that vehicle is?
25,000.
Okay. Do you recall doing some research on those vehicles and looking at like kellybluebook.com?
Me personally?
Or we for purposes of the trial?
Yes, you did.
Okay. And do you recall, I'm gonna turn to what's been marked as exhibit number 16 at this point. Do you recall this document being prepared?
Yes,
Okay, and can you provide what that document says for the court?
$27,519.
Okay, and do you think that that's an accurate representation of your vehicle?
Yes,
And does it note that that's your vehicle on the top left-hand corner?
yes.
Okay, at this point, Your Honor, I move to admit what's been marked as exhibit 16.
Mr. Geis, any objection to the court admitting exhibit 16?
No.
Exhibit 16 is admitted.
Thank you. Natasha, is there a current debt on that vehicle?
Yes,
Okay, and do you recall what the debt of the value of the debt at the date of separation was?
no.
Okay. Okay, if I showed you a document that we provided to the court, which may have that on there, would that refresh your recollection?
Yes,
Okay, so I'm handing you what's been marked as exhibit 18. Can you provide a little bit of information on what that document is to the court?
this is the bank statement on the account for what the vehicle's loans through.
Okay, and can you see what the value of the data separation was on that document?
$34,977.32.
Okay, and is that an accurate representation of the account that your vehicle is financed through?
Yes,
Okay, at this time I move to admit 18.
Any objection, Mr. Geis?
No, sir.
Okay, 18 is admitted.
Thank you. Moving on to what Mr. Geis drives. What vehicle does he drive?
I can't remember the year, but it's a Silverado.
Okay.
Chevy truck.
If I told you it was a 2018 Chevy Silverado, does that refresh your recollection?
Yes,
Okay. And when was this vehicle purchased?
I can't remember.
Was
It
it
was after mine.
Okay, but it was
Or no, it was before mine. Sorry, I had a different car for the Tucson.
That's okay. It was purchased during the marriage though.
Yes,
Okay. And to your knowledge, is that vehicle in good condition?
yes,
And do you recall what the value of that vehicle is?
no,
Do you remember us preparing a Kelly Blue Book on that vehicle for purposes of trial?
yes,
If I showed you that document, would that refresh your recollection?
yes.
Okay, so I'm handing you what's been marked as exhibit 17. Can you describe that document for the court?
It says fair purchase price for a 2018 Silverado is $32,115.
Okay. Do you believe that that's an accurate reflection of Mr. Geis's vehicle?
Yes,
Do you believe that's an accurate reflection of the value of that vehicle?
yes,
Okay, at this time I move to admit 17.
Any objection to the court considering it admitting exhibit 17, Mr. Geis?
No objection.
Okay, 17 is admitted.
Thank you. To your knowledge, Natasha, is there a debt on this vehicle?
yes,
And do you recall what the debt amount of the data separation was?
no,
If I showed you a bank statement, which I believe encompasses that debt, would that refresh your recollection?
yes.
I'm handing you what's been marked as exhibit 19. Can you describe that document for the court?
This is the bank account loan for Jacob's truck. And it says $29,518.54.
Okay, and is it your understanding that that is the account for that truck?
Yes,
And that is the value in the data separation for the loan of that truck?
yes,
Judge, at this time I move to admit 19.
Any objection to 19 being admitted?
No objection.
19 is admitted.
And Natasha, who are you asking the court award this asset to?
the truck to Jacob,
Okay, and I didn't ask you for the Tucson. Who are you asking the Tucson to award it to?
me,
Okay, and these are both vehicles that both of you have driven and currently drive?
yes,
Okay. I want to turn next to some bank accounts that you held during your marriage. What bank account do you currently use?
the fiber,
Okay, and is that the one ending in 922?
yes,
Okay, and when was this account opened? Was it open during the marriage?
Yes,
Okay, and you had access to this account prior to separation,
yes,
and even after separation, you've continued to use this account.
yes,
What funds were used to open this account?
mine,
Okay, and when you say yours, was it from like your paychecks?
yes,
Okay. And who are you asking to be awarded this account?
me,
Okay. I have provided to the court what's been marked as exhibit 13, and I'm gonna show you that right now. Is that a document from your bank account?
yes.
And when was the date of that document?
The date, 3/4 to 3/31/2022.
Okay, so this document encompasses the date of separation.
Yes,
Okay, and what was the value of this at the date of separation?
$1,005.24.
Okay, and this is an accurate reflection of that account at the date of separation?
Yes,
Are you, and you're asking the court to award you this account?
yes,
Okay, at this time I move to admit 13.
Any objection?
No.
13 is admitted.
Do you have any other bank accounts?
besides the loan for the car, no.
Okay, and is that loan through Red Canoe?
Yes,
And is that valid, or is that account ending in 27?
yes,
Okay, and this was.
Is that for the Tucson, the 27 account?
Yes.
Okay, thank you.
Judge. And this account was opened during the marriage,
yes,
and this account remains open currently.
yes,
Okay, and this account, do you solely use it for the loan for the vehicle?
yes, that's all I use it for.
Okay, you never deposit any money into it or use the savings account or checking account?
No,
And that's been marked as exhibit 14. Can you tell the court what this document is?
this is the loan information and the balance on the Tucson.
Okay, and what is the date of that document?
3/1 to 3/31/2022.
Okay, so that's an accurate reflection of the debt value as of the date of separation.
Yes,
At this time, I move to admit 14.
Any objection?
No objection.
14 is admitted.
So do you have any other bank accounts?
no,
Okay, how about Mr. Geis? Do you know what bank account he has?
I know as far as he has the Red Canoe account, I don't know about anything else.
Okay, and is that the account ending in 746?
I believe so.
Okay, I'm gonna show you what's been marked as exhibit 15. Can you describe this document?
Jacob's bank account at Red Canoe for savings and checkings.
Okay, and to your knowledge, was this account open during the marriage?
Yes,
And did you ever have access to this account?
yes,
Okay, did you and Mr. Geis both deposit and withdraw money from this account?
yes,
Okay, who are you asking to be awarded this account?
Jacob.
Okay, and did you indicate the date in which is listed on that document?
3/1 to 3/31/2022.
Okay, and what is the value as of that document? Or the value of the account, does it say how much the balance is?
$405.
Okay, and are you asking this be awarded to Mr. Geis?
Yes,
Okay, at this time I move to admit 15.
Any objection?
No objection.
15 is admitted.
Yeah. Do either you or your husband have any retirement accounts, investment accounts, pensions, anything like that?
yes,
Okay, and who has those?
Jacob does.
Okay, and did he acquire this during the marriage?
Yes,
And where is this account through?
Teamsters
Okay.
Union?
Okay, and is that from his employment during the time?
Yes,
Okay, I'm gonna look at what's been marked as exhibit 12. Can you describe for the court this document?
the Teamster Pension Trust, and it shows Jacob's plan coverage.
Okay, does it have a value on this account?
Yes,
And what does that say?
$663.84.
Okay, and is there another value next to that number?
It's $3,457.37.
There you go. Is that the value that you believe that the account is worth?
Yes,
Okay. And who are you asking this be awarded to?
Jacob.
Okay. At this time, I move to admit 12.
Any objection?
No objection.
12 is admitted.
So aside from some, maybe some personal property, clothing, things like that, but that's pretty much the bulk of your assets that you've acquired during the marriage. Is that correct?
Yes.
Okay. So let's move to some debts. Unfortunately, you both have acquired quite a bit of debt throughout the marriage.
Yes.
Okay. So let's kind of go through some of those debts. Did you bring in the Target card when you married?
Yes.
Okay. And is that the 8316 Target card?
Yes.
Okay. And I'm going to show you what's been marked as Exhibit 28. Can you describe this document for the board?
The summary of account activity for my Target card.
Okay. And what is the date of that statement?
March 27th, 2022 was the closing date on it.
Okay. And what was the value of that debt as of the date?
$4,400.26.
And what was this debt used for, or what was this card used for?
At this time, a majority of it was purchases made for Zeke.
Okay. And when you say purchases for Zeke, what kind of purchases?
Clothes, preparing for the arrival of him, and formula, diapers, everything.
Okay. Did Mr. Geis have any access to this card?
No.
Okay. But the card was used to buy things for the child that you both share.
Yes.
Okay. And who are you asking be awarded this debt?
Me.
Okay. At this time, I move to admit 28.
Any objection?
No objection.
28 is admitted.
Turning next to the Amazon Prime 9484 account. Do you recall what this account is?
Yes.
Okay. And when was this account opened? During the marriage?
Yes, during marriage.
Okay. And what did you primarily use this account for?
Purchases for the house and family.
Okay. Did Mr. Geis have any access to this card?
No.
Did he reap the benefits of this card?
Yes.
Okay. I'm handing you what I've marked as Exhibit 29. Can you describe this document for the court?
Account summary for my Amazon Prime account.
Okay. And what is the date on this card, or on this statement?
April.
Is there a statement, or is there a pay slip?
Oh, there we go. 3/11. So
3/11 of
2022. Sorry.
Nope, you're fine. And what was the value during this date?
The balance on it $692.17.
Okay. And have you continued to use this account after separation?
Yes.
Okay. So who are you asking to be awarded this account?
Me.
Okay. At this time, I move to admit 29.
Any objection?
No objection.
29 is admitted.
I want to turn to the Fiber Federal Visa ending in 922. What is this account?
This is my credit card.
Okay. And was this opened during marriage?
Yes.
And you've continued to use it since separation?
Yes.
I'm going to hand you what I marked as Exhibit 30. Can you tell the court the date of this document?
3/7/2022 to 3/11/2022.
Okay. And what was the balance owing at the date of separation during this statement?
$4,116.88.
Alright. And you indicated that you've continued to use this account since separation.
Yes.
Is the value larger than that $4,000 amount?
Yes.
Okay. Nevertheless, who are you asking to be awarded this debt?
Me.
Okay. At this time, I move to admit 30.
Any objection?
No objection.
Well, could you repeat that?
No objection.
Great, thank you. 30 is admitted.
Do you have any other debts other than the ones that we've just gone through?
No.
Okay. To your knowledge, does husband have other debts?
Yes,
Okay, and did we uncover those during discovery?
yes,
Okay, so I want to look at, does husband also have a Target red card?
apparently,
Okay, did you ever use this card?
no,
Did you ever have access to this card?
no,
Um, Are you asking that this account be awarded to him?
yes,
Looking to the Red Canoe Visa, ending in 746, do you recall this account?
no,
Okay. Do you, after going through discovery and learning of this account, did you learn that this is one of Mr. Geis's cards?
yes.
Okay. I'm gonna show you what's been marked as Exhibit 20. Can you describe this document for the court?
Summary of account activities for 3/31/2022,
Okay, and what was the balance owing at that date?
$479.33.
And who are you asking to be awarded this account?
Jacob,
Okay, thank you. And first time I moved to admit 20.
Any objection? Oh, Mr. Geis, it came through very muffled and I wasn't able to distinguish what you said.
Can you hear me better now?
Yes, much more clear. Any objection to admitting Exhibit 20?
No objection.
20 is admitted.
Did you become aware that Mr. Geis also had a Red Canoe line of credit?
yes,
Okay, and you learned that through discovery as well?
yes.
Let me show you what's been marked as Exhibit 21. Can you describe this account for the court?
The line of credit through Red Canoe,
Okay, and what is the date of that statement?
3/10/2022,
And does it have a balance as of that date?
$3.09.
Did you ever use this account during the course of your marriage?
No,
Okay. Are you asking that this account be awarded to husband?
yes,
Okay, at this time I move to admit 21.
Any objection?
No objection.
21 is admitted.
Similarly, did you learn through discovery that Mr. Geis also has a Capital One card?
yes,
And is that ending in 9036?
yes,
And did you know of this account during marriage?
no,
Do you know what this account was used for?
no,
Have you, I'm gonna actually show you what's marked as Exhibit 22. Can you describe this statement for the court?
Capital One payment information for the payment due, all right, account, where is it? February 22nd to March 24th, 2022.
Okay, so this encompasses your date of separation. What was the balance owing on this account?
$964.77.
And who are you asking to be awarded this to?
Jacob,
Okay, at this time I move to admit 22.
Any objection?
No objection.
22 is admitted.
Did you also learn that Mr. Geis has not one but two different Credit One accounts?
yes,
Okay, let's talk about the 7728 account first. Primarily, did you know of this account during your marriage?
no,
You did not know of its existence or that Mr. Geis was using it?
no,
Did you know that there was an outstanding balance on this account during that time?
no.
Okay, I'm handing you with the Marcus Exhibit 23. Can you tell the date of that document for the court?
Statement closing date was 4/9/2022.
Okay, so this was just after your date of separation?
Yes,
Okay, and what was the balance owing at that date?
$567.30.
Okay, and did you obtain this document through discovery?
Yes,
Okay, and who are you asking to be awarded this day?
Jacob,
This time I move to admit 23.
Any objection?
No objection.
23 is admitted.
Let's look at that other credit loan account, that 5360 account. I'm showing you what's been marked as exhibit 24. Similarly, did you know of this account's existence?
No,
And did you also learn this through discovery?
yes,
And you obtained this document through discovery?
yes.
And what is the date of this?
So hard to find these dates. The statement closing date's 3/26/2022.
Okay, and this was also around the time of your separation?
Yes,
And what was the balance owing as of the statement?
$436.93.
And who were you asking to be awarded this debt?
Jacob.
Okay, at this time I move to admit 24.
Any objection?
No objection.
24 is admitted.
Did you learn of a PayPal account of Mr. Geis's?
Yes,
And how did you learn of this?
discovery.
Okay, and you did not have any knowledge of this during your marriage?
No,
Did you know what this account was for?
no.
Okay, I'm handing you what's been marked as exhibit 25. Can you describe for the court that document?
Statement closing date 3/25/2022, PayPal credit card account.
Okay, and what was the balance owing as of this date?
$79.77.
Okay, and who are you asking to be awarded this debt?
Jacob.
Okay, at this time I move to admit 25.
Any objection?
No objection.
25 is admitted.
Did you know of a upgrade personal loan account that Mr. Geis had taken out?
No,
And how did you learn of this account?
discovery.
Okay. You did not have any discussions with Mr. Geis during your marriage regarding this account?
Not that I can remember.
Okay. Do you have any idea what this account was used for?
No.
Okay. I'm handing you what's been marked as exhibit 26. This is the upgrade 8191 account. Can you provide a date of this statement for the board?
So 2/20/2022 to 3/22/2022.
Okay. So this statement encompasses your date of separation.
Yes,
And what was the balance as of the date of the statement?
$1,903.11.
And who were you asking to be awarded this account?
Jacob.
Okay. This time I move to admit 26.
Any objection?
No objection.
26 is admitted.
And lastly, at least that we know about, the Sunbit credit card 2431. Did you know of this account's existence during your marriage?
No,
How did you learn of this account?
discovery.
Okay, I'm handing you what's been marked as exhibit 27. Can you describe this document for the court?
Sunbit summary of account activity for, Sunbit credit card services.
And what is the date of this statement?
Closing date was April 3rd, 2022.
Okay, so is it fair to say that this also encompassed your data separation?
Yes,
Okay, and what was the balance as of this statement?
$2,426.75.
Okay, and who are you asking this debt be awarded to?
Jacob.
Okay, at this time I move to admit 27.
Any objection?
No objection.
27 is admitted.
Now, Natasha, we had provided a balance sheet to the court that kind of just outlined the various assets and debts and who you propose they be awarded to, is that right?
Yes.
Okay, and all of the assets and debts that we just spoke about are included on that balance sheet?
Yes.
Okay, thank you. And do you believe that this is a fair distribution of both the assets and the debts?
Yes.
Do you acknowledge that even though on the balance sheet, you're taking on substantially more debt than Mr. Geis, you're still asking the court adopt your proposal?
Yes.
Okay. Let's talk about your income. What do you do for work?
I'm home carried.
Okay, and
I didn't hear the answer very clearly. I apologize.
okay, say again.
I'm a home carried.
A home carrier, okay.
Thank you.
Yes, and do you get paid hourly, salary? Hourly, and what do you make per hour?
I'm not sure. I'm sorry.
That's okay. Did we provide pay stubs for the court to consider today?
Yes.
If I handed you those, would that refresh your recollection?
Yes.
Okay, I'm handing you what's been marked as exhibit 2. And what are those documents?
My pay stubs.
Okay. And are those an accurate reflection of your pay stubs?
Yes.
And to your knowledge, they haven't been altered or modified?
No.
Okay. And on that document, how much does it say you make per hour?
$22.59.
Okay. Do you foresee any raises in the future or any bonuses in the future?
Yes.
Okay. And do you have any idea as to when those will occur?
My union fought for every 6 months we get a raise.
Okay. And when is that 6-month period going to occur? Do you know?
I don't.
Okay. But as of right now, this is an accurate reflection of your wages.
Yes.
Okay. I move to admit exhibit 2.
Any objection?
No objection.
2 is admitted.
And it looks like with your pay stubs, you roughly earn about $2,700 per month. Is that fair to say?
Yes.
Okay. And this is pretty standard for your typical income?
Yes.
Okay. I want to show you what's been marked as exhibit 1 for you to tell the court what this document is.
Tax return 2022, this was mine.
Okay, and did you file jointly or separately for this year? The 2022 year?
Separately.
Okay, and what was your year-end income as of 2022?
31,470.
And is this an accurate reflection of your tax return that year?
Yes.
And to your knowledge, nothing's been altered or modified?
No.
At this time, I move to admit exhibit 1.
Any objection?
No objection.
1 is admitted.
For purposes of child support, are you asking the court to use your actual net income, that $2,700 figure that we just spoke of?
I do believe so, yes.
Okay, and you believe that that's an accurate reflection of your current income?
Yes.
Okay. And what are you asking the court to do for Mr. Geis's income?
To use the income that he was making when we first separated.
Okay.
While we were still married.
Okay, let's talk about that. So you're asking the court to impute him in a different income than what he's currently making, and why is that?
I feel that he quit his better paying job on purpose to lower his child support obligation.
Okay, and we've provided some documentation to the court that we'll discuss a little bit later regarding his various jobs that he's had over the course of this case. Is that correct?
Yes.
Okay. So for purposes of our child support worksheet, we're asking the court to use an income of roughly $4,200 per month for him. Does that sound about right?
Yes.
Okay. Does Mr. Geis have any other children that he's required to support?
Yes.
And is that Elijah that we spoke of earlier?
Yes.
To your knowledge, is he paying child support for Elijah?
Yes.
Okay. With that understanding, are you asking the court to award him a whole family deviation?
Yes.
Okay. With that deviation and with those income calculations, are you asking the court to order him to pay child support in the amount of $523.58?
Yes.
Okay. For purposes of the tax exemption and claiming Zeke, are you asking the court to award you the tax exemption every year?
Yes.
And why are you asking that?
Because Zeke's primarily in my care.
Okay, so we'll get to visitation in a moment, but the majority of the time, Zeke is in your care. Do you have any extra expenses that you're not able to cover with the monthly child support?
Yes.
And what are those expenses?
Childcare.
Okay, so childcare is an issue. Is any medical expenses for Zeke an issue?
No, not at this time.
Okay, and that's because he's on state insurance?
Yes.
Okay, so there's some daycare expenses, obviously his day-to-day needs, and you don't believe that the current child support or the child support that would be entered would be enough to furnish those fees?
Yeah.
Okay, and you believe that a tax exemption should be awarded to you every year because of that?
Yes.
Okay. I want to turn to the issue of attorney's fees. You've paid quite a bit to have me as your counsel, is that correct?
Yes.
Okay, and we provided a fee affidavit to the court that kind of encompassed all of the fees that you've paid me. Do you recall that?
Yes.
Okay, and do you recall roughly how much you've paid me as of today?
Over 10,000?
Okay, did we estimate after today's date that you'd owe me about $12,000?
13.
13, there we go, okay. Did you make attempts to resolve this case during the lifetime of the case?
Yes,
Okay, did we attempt a settlement conference?
yes,
Did Mr. Geis attend that settlement conference?
no,
To your knowledge, was he forthcoming with discovery?
no,
To your knowledge, has he attempted to resolve this case at any time during this case?
no,
So is it your position that you filed the case and getting it to finalization was on our doing?
yes,
Okay. Are you asking the court to order a contribution towards your attorney's fees?
yes,
And what are you asking the court to award?
10,000,
Okay. And you believe that this is fair given the behavior of Mr. Geis throughout this case?
yes,
Okay. I want to turn to the most important part of this case. That's Zeke.
yes.
Can you tell the court how old Zeke is?
He just turned 2 in October.
Okay. So 2-year-old, a toddler. Is he walking?
Yes,
Does he have the toddler hunger, growing pains?
yes.
Yes, okay. So let's talk about, since Zeke has been born, kind of what your role in his life has been.
I do everything. I take care of him. I was on maternity leave and I did everything by myself. Sorry. I did all the feedings, all the changings. I was lucky if I got a diaper change out of Jacob when he would come home from work. He wouldn't let me take a shower. If I asked him, I had to ask him for permission to even take a shower during my maternity leave. I would have friends and family come over to help me a little bit, and just so I could try to so I'm home carried and I take care of an elderly lady, and of course she went without when I was on maternity leave, but I felt bad, so then I'd have a family member come over and watch Zeke for me so I could go check on her. And Jacob wouldn't even watch Zeke at that point. He would be sleeping in the bedroom during the first 4 months that we were still together after I had Zeke. Now I have a friend taking care of Zeke that's been there since he was about 5.5 months old, and she does really good at what she's taking care of Zeke for me. I'm not sure if I'm making any sense, but I pay all the bills and stuff by myself. She helps me out a lot, and then it's just me and him in the evenings and the mornings when I'm not at work, so.
Okay, that's good. So while you've cared for Zeke, do you play with him?
Yes,
Do you provide him, teachings and guidance?
yes,
Unfortunately, sometimes you have to be a disciplinarian too, is that correct?
yes,
Okay. Is he, so he's only 2, he has a daycare provider currently.
yes.
Are there other children in that daycare?
No, he
Okay.
gets taken care of at my house.
Okay. Do you provide him social interactions?
Yes,
To the extent of raising Zeke, who primarily does that?
I do.
Okay. And you kind of touched on during your relationship while you and Mr. Geis were still residing together, kind of what his involvement was. Was that the extent of his involvement?
Yeah, it was very minimal.
Okay. So you indicated that getting him to change diapers was difficult.
Yes,
Watching him while you took a shower or went to work was difficult?
yes, or even feeding in a bottle.
Okay. So his primary caregiving was by you,
Yes,
and that's continued even after separation?
yes,
Okay. Let's talk about your bond with Zeke. Do you have a strong bond with Zeke?
yes.
Okay, and how would you describe that?
I didn't realize how much I could love someone until I had him. Sorry.
It's okay.
It's very strong. I would do anything for him.
And how would you describe Zeke's relationship with Mr. Geis?
I have no idea.
Okay. Have you spent much time interacting or watching the 2 of them interact since you've separated?
No,
Okay. Let's talk about Zeke's medical appointments. Historically, have you made those appointments?
yes,
Have you attended those appointments?
Yes,
Would you say all of those appointments?
yes.
Okay. And to your knowledge, how often has Mr. Geis attended those appointments?
He's only attended one.
Okay. And what was that appointment? Do you recall?
It was a doctor's appointment,
Okay.
just for a checkup, and he got a shot.
Okay. So since Zeke has been born, you've attended every doctor's appointment.
Yes.
Does he go to the dentist?
Yes,
And do you attend those appointments?
yes,
Has Mr. Geis attended those appointments?
no,
Okay. Has there ever been a time where Zeke has needed emergency medical care?
yes,
And have you tended to those needs?
yes,
Have Mr. Geis?
no.
Let's talk about that. So what was the incident where Zeke needed some emergency medical care?
Well, I thought he needed emergency medical care. He fell off of his dresser and he stood up for a second. He has a bookshelf above his dresser that he was reaching for, and his changing table's on top of his dresser, so that's why he was on top of it. And I turned my back for a second and he fell off, and when I picked him up, I noticed that his face was pretty smashed in. It wasn't bleeding or anything, but I was scared that he needed to go to the emergency room, so I took him. At the time, I could not get a hold, Jacob has me blocked on his phone. My babysitter came with me because we were getting ready for bed, so she actually turned around and came back over to the house to come with me to the emergency room. And she called Jacob from her phone, and Jacob hung up on her. And then he proceeded to tell me that I would have to tell him everything that was going on through text, and he refused to come to the emergency room.
And when this incident happened, was the emergency room close to Mr. Geis's home?
Yeah, like not like 5 minutes if that away from his apartment.
Okay. So even under a pretty scary situation where you had to take your child to an emergency room, Mr. Geis didn't attend?
No,
Okay. You indicated Mr. Geis has you blocked on his phone?
Yes.
Is that correct? Okay. So you're unable to call him
yes,
or text him
yes,
in the event of any sort of emergency or major issue, you could not get a hold of him?
yes,
Okay. How do you communicate with Mr. Geis currently?
email,
Okay. And is that sustainable in emergency situations?
no, that's why I use my babysitter's phone.
Okay, okay. So I want to talk about our proposed parenting plan. You're asking for the court to make some limiting factors under that section 3 area. Do you recall that?
Yes,
And has the court already made findings under this section?
yes,
Okay. Primarily regarding neglect, is that
Yes.
correct? Okay. And is that, we kind of covered it just recently about Mr. Geis having a minimal involvement in Zeke's care and caregiving. Is that why you're asking the court to make this finding?
yes,
Okay. Did Mr. Geis have any issues with alcohol or substances during the relationship?
yes.
And can you provide the court a little snapshot of what that looked like?
So while I was pregnant, Jacob started drinking very heavily, and one of the worst incidents I remember was 4th of July. He had ended up drinking a 5th of peanut butter whiskey, and he proceeded to, after he drank that 5th by himself, he proceeded to mix energy drinks with tequila. And at the time we were with family, his family specifically, and he had gotten so incoherent to the point where he was falling, he couldn't stand, couldn't walk, he could barely talk. And I had to leave him at his uncle's house because I was pregnant and I wasn't going to carry him home. And yeah, he ended up falling on his face, busting his lip open, his nose was swollen. It was not a good situation.
Okay, so that was one occurrence. Were there other occurrences during your relationship with him where you observed him having an alcohol problem?
Yes, several.
Okay, and even after separation, did you still have concerns regarding his alcohol use?
Yes,
Okay, did you ask the court to order in a previous hearing a alcohol evaluation?
yes,
And to your knowledge, was that completed?
yes,
To your knowledge, was Mr. Geis recommended treatment?
no,
And to your knowledge, why was he not recommended any treatment?
he was sober at the time.
Okay. Within that evaluation, was he labeled high risk for relapse?
Yes,
Okay. And is that why you're asking for limitations regarding alcohol and drug use during his time with Zeke?
yes,
Now we say drug use. Do you have concerns regarding Mr. Geis using drugs?
I do. So, I mean, I don't want to, but I can't trust what he says.
Okay. And why do you have those concerns?
Because he's had a history of using drugs in the past.
He has, okay. And have there been discussions regarding drug use within his home?
Yes.
Okay. Is it your understanding that he is residing with no drug users?
He was.
Okay.
So it's the situation, he told me that he was staying with his mom during the week to be closer to work, because she lived in Vancouver and he works in Battleground. And so during the week, he was staying in Vancouver with his mom instead of his Longview residence here in town.
Okay. And to your knowledge, were there drug users in his mother's home?
Yes, and he told me that himself.
Okay. Did he say what types of drugs they were using?
They're using coke.
Cocaine?
Yes.
Okay. No, you're fine. And to your knowledge, does Mr. Geis have a history of cocaine use?
Yes, when we first got together, he was trying to use cocaine with his neighbor, and I told him if that was gonna happen, then I didn't want to be with him.
Okay. To your knowledge, was there any other drug use during their relationship?
Marijuana.
Okay. And has Mr. Geis been open with the court that he continues to use marijuana?
Yes.
Okay. Do you have concerns about his marijuana usage when Zeke is in his care?
Yes.
And why was that?
When he used it previously in our relationship, it was just, he would use so much, like, there was no control of it, he couldn't, I mean, it was bad.
Okay. Do you believe that when he's using marijuana that he is able to adequately care for a 2-year-old?
No.
Okay. Is that why you're also asking for those limitations in your parenting plan, prohibiting him from using while or prior to his time with Zeke?
Yes.
Okay. We spoke a little bit about kind of the roles in decision making for Zeke. So when he gets immunized, who makes those decisions?
I do.
When he needs a doctor's appointment, who makes those appointments?
I do.
If he were to need emergency medical care, who would take him to the hospital?
I would.
If he needed to have some sort of medical procedure, who would make that decision?
I would.
At any point, has Mr. Geis shown any interest in making any of those decisions?
No.
Are you asking the court to order sole decision making to you with regards to his medical and schooling decision making?
Yes.
And is that largely what you've been doing already?
Yes.
Okay. What's the current visitation schedule between Zeke and Mr. Geis?
He gets 1 8-hour visit a week, rotating Saturday and Sundays.
Okay, so if we were to kind of break that down a little bit, he'll get 8 hours on a Saturday and then the following Sunday or the next week?
The next
Sunday.
week.
Okay, so 1 8-hour visit per week.
Yes.
Okay. And how long has this been occurring?
Since the temporary orders were in place.
Okay, and has Mr. Geis consistently exercised his visitation?
Yes.
Okay, have there been times that Mr. Geis hasn't exercised visitation?
Yes.
And why is that, to your knowledge?
He had to work.
Okay, to your knowledge, does he typically work weekends?
Yes.
Okay, has he ever asked to switch days?
Yes.
Okay, and what have been the circumstances surrounding that?
The switching days, because he wanted to work.
Okay, so you said he wanted to work, so he didn't have to work, he's simply choosing to work?
Yes.
Okay, and we've discussed Elijah, his other child. Do you have any understanding of what his visitation is with that child?
He currently does not have visitation at this time.
Okay, historically, did he have, Elijah and Zeke on the same schedule?
Yes.
And were there any concerns with that schedule?
Yes.
And what were your concerns with that?
My concerns is Elijah and Ezekiel being left unsupervised together.
Okay. And did Mr. Geis tell you himself that he had left them unsupervised together?
No.
Okay. Did Elijah's mother tell you this?
Yes.
Okay. To your knowledge, how old is Elijah?
8.
Okay. So it's your understanding that an 8-year-old and a 2-year-old have been left alone?
Yes.
Okay, and that's when they are in Mr. Geis's care?
Yes.
Okay. Do you have any concerns with the current residential schedule?
So not the current, no.
Okay. Do you have concerns with expanding beyond the current schedule?
Yes.
And what are those concerns?
That Elijah and Ezekiel will have to share a bed and that they will be left unsupervised together at night.
Why are you concerned about Elijah and Ezekiel being left alone, unsupervised, either at night or daytime?
Elijah has a history of animal abuse and he has been in extensive therapy in the past and he's currently in therapy. So he has some issues that he's working on.
Okay. And during your relationship with Mr. Geis, did you personally observe some concerning behavior with Elijah?
Yes, on several occasions.
Okay. During the few months essentially that Ezekiel and you and Elijah and Mr. Geis all resided together, did Elijah behave inappropriately towards Ezekiel?
Yes.
And what were the situations regarding that?
He would get very upset if Jacob would show any attention to Zeke. He didn't want to share a space with him. He wouldn't want Zeke to stare at him even. He would just get upset.
Okay. And is this, so obviously there's, some sibling rivalry or the introduction of a new child, usually there's a learning curve. Do you believe that that's what it was, or do you believe it was something more than that?
I want to say like Jacob probably had something to do with it too because of the way that I feel Zeke was being treated by Jacob. And yeah, I don't know.
Okay. So if the schedule were to expand beyond what it is currently, would you ask the court to prohibit them being left alone together?
Yes.
Okay. Are you open to expanded visitation somewhere down the line when Ezekiel's a little bit older?
Yes.
Okay. Why are you concerned with him having extensive time now when Ezekiel is 2 years old?
I'm concerned because Zeke can't tell me what's going on. Okay. So I'd like to wait until at least he can say, if something's happening.
Okay. Because you do have concerns of what occurs in dad's household.
Yes.
Okay. So arguably when Zeke is old enough to, voice any concerns, you would not be opposed to expanding visitation?
No.
Okay. Also presuming Mr. Geis remains sober and has those alcohol and marijuana prohibitions in place?
Yes.
Okay. Lastly, do you believe that schedule that we've proposed and kind of what we've just outlined is in Ezekiel's best interest?
Yes.
To furnish, him growing up and being a productive kiddo and member of society?
Yes.
Judge, at this time I have no further questions.
Okay, thank you. Mr. Geis, cross-examination, any questions you'd like to pose?
Yes, I would like to ask questions.
Okay, go ahead.
Miss Natasha, do you recall that when I was presiding at the house, that I was also working a 12-hour shift, graveyard shift, with 1 hour drive each way during the time that was stated that I was just sleeping during the day? Because that time that I was sleeping was the only time I was at home for between the shifts.
Ask me a question.
Okay, so Mr. Geis, if you could phrase the question and pose the question, please.
Is it to your recollection that I worked 12-hour graveyard shifts, and the time that I was at home, I was sleeping because that was my only time that I could sleep?
No, I don't remember.
Okay. Is it to your recollection that childcare is currently taken out of my paychecks?
Yes.
Is it to your recollection that I have previously stated that I cannot afford to take time off of work, and that it's not logical for both parents to take the time off of work to attend doctor visits if they're non-emergical?
Yes.
Is it to your acknowledgement that I had stated that I was not staying with my mom in Vancouver for that week period of time, that I was staying with my grandma Ramona.
You told me you were staying with your mother.
Okay.
And your mom told me that your grandma refused for you to stay at her house.
Okay. It was even over text messages and emails stated that I got what I wanted by moving out of the house. Do you recall that I attempted to move out of the home 3 different occasions?
No.
I have no further questions.
Okay, redirect.
Just one question. Natasha, is Mr. Geis current in his child support obligation?
No.
And to your knowledge, how much is he currently over?
Over 3,600.
I didn't hear the figure. Can you repeat that?
3,600 over.
3,600.
Yes.
Thank you.
So he owes $3,600, and to your knowledge, that's for child support arrears.
Yes.
To your knowledge, does he also have daycare arrears owing?
I had to turn the daycare arrears into DCS because Jacob refused to pay them.
Okay, so DCS is now garnishing his wages for daycare expenses as well?
Yes.
To your knowledge, is he current in those expenses?
No.
So there's outstanding expenses for those as well?
Well, it's all together on the DCS. Whatever he owes DCS is what he owes for childcare.
Okay, so that $3,600 is essentially child support, child care, all arrearages? Okay, very good. I have nothing further.
Any recross examination on that issue, Mr. Geis?
I apologize. I didn't take any notes to ask cross-examination, so no, not at this time.
Okay. All right. Thank you. All right. That concludes the testimony of Ms. Geis. Ms. Bliss, would you like to call your next witness?
That is my sole witness, Your Honor, so this time we would rest.
Okay. All right. And Mr. Geis, the time is yours to call witnesses, including yourself.
Judge, I don't mean to speak out of turn. Is there a way that we can take a brief 5-minute restroom break?
Sure. Yeah,
Yeah.
it's 10:11 now, so let's plan on coming back at 10:26. We'll come back at 10:26 and resume things. I'll keep
Very
this going and turn off my camera. All right, we're back. Thanks for being punctual. I'll double check with Madam Clerk to make sure we're on the record.
You're on the record, Your Honor.
Perfect. Thanks so much. All right. Before the break, Ms. Bliss and her client rested their case, so that means they're not presenting any additional direct testimony at this point. So we'll turn to Mr. Geis. And Mr. Geis, if you'd like to call your first witness.
I'd like to call upon myself.
Okay. All right. If you'll please raise your right hand, I'll administer the oath to you. Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Will you please state your full name and spell your last name?
Jacob Paul Geis, Giese.
Thank you. Go right ahead, please.
All right. So do I ask myself questions or do I just?
You can just go ahead and just tell your story, tell your narrative.
Okay, so at the time upon me leaving the home that me and Natasha shared, there was a lot of disagreements amongst each other, and had primarily to do with my son Elijah, and that there was a disagreement upon him being new to being the only child. And so because I did have him as my only child, I did give him all of my attention. And then it was expressed to me that during, that I wouldn't ever be as fond or love Ezekiel the same way as I do Elijah, which isn't fair to say because I can love them both equivalently, but separately at the same time. So at one point in time, I can't recall exactly what this situation was. Me and Natasha had gotten to an argument, and I had uh, tried to evade the conflict, and it was resulting in backlash on Elijah to the point where I was uncomfortable with the situation, and I had, in 3 different occasions, I had packed my bags and said I was going to move out. Each time that was the case, I was always contacted that she wanted me to come back to the house, in which I did, except for the last time I had to make a decision that um, this revolving door needed to come to an end. And so at that point in time, I had to make this decision based upon how it was affecting my child. And I couldn't put my personal feelings in the situation, how I felt about Natasha. So I even have, though I didn't submit it, I have documentation stating that I am the one that asked for this in the first place and that I'm getting what I want. I feel that was probably valuable information for me to present, which I didn't take the opportunity to do that. As far as when I was in the home with Natasha, and she had stated that I was sleeping and not giving the child care and such along those lines. I was working a graveyard shift, I was working 12 hours a day, and I was working in Vancouver. So from Longview to Vancouver is 45 minutes, and I was having to drive. So that accumulatively is about 14 hours a day. And so when I'd come home, I'd spend an hour with them and before I'd go to bed. And then in the morning time, or my morning time, uh, I'd spend a little bit of time with them amongst getting ready to go to work and then go to work. And so there was no at home time really during my working shifts. The days that I had off, I had to also adjust my schedule to meet the schedule of a normal life. And and upon that, I was also having the care of my son Elijah. Um, I don't know how to further elaborate that whole concept of that situation, is because it was complex given the circumstances, and I never was abandonment to any of my children. Uh, there, as along the lines of her feeling like that she didn't have help. The days that I was working, I wasn't able to help her. I admit to that. But the days that I wasn't working, I always put forth my most effort to the situation. And so I can't say that she didn't struggle, because I know that she did. And it's unfortunate, but the circumstances weren't providing. And so upon this is a different matter. Has to do with the child care and what's back owing, and what was stated is that I was refusing to pay child care at the time that this was a circumstance. It's not accurate to say that I was refusing to pay it, but I couldn't afford it, because when I worked at Great Western Malting, I made $25.51 an hour, and I couldn't afford the drive back and forth. And so upon that, I had previously worked for a gentleman up in Longview area, and he said he'd get me a job so that way I didn't have to travel so much. The job that I retained at that time was $24 an hour. And so both, I couldn't afford the drive to make it to Great Western in Vancouver. And then when I got the job up in Longview, which I was barely able to make it at that point in time based off of now I'm paying more money in child support, and I'm happening to cover more of financial responsibility because it's not a shared income household at this point in time, having to move into a new home and such. At this time, childcare is currently taken out, and it was kind of enforced, but at the same time, that's not exactly the case because I had just recently achieved getting this job that I'm working at this current time, which is it's more sustainable work. It's better pay. Me making $30 an hour makes a huge difference. I'm working in Battleground, Washington, which is still a 45-minute drive, but that $5 an hour difference really makes or breaks the situation. So that being said, I understand that at a point in time, I was in a financial disposition where I couldn't afford to meet the needs, and it's not Natasha's responsibility. I do accept responsibility in the matter, but I also know that I had to decide whether or not I could pay my rent or my truck payment to be able to make it work because I don't have another vehicle, or to try to push further on, unfortunately, putting myself behind and putting Natasha in a situation. um, so at this point in time, I put all my communication with Natasha over email, which may not sound super appropriate, but when we were having telephone communication and she would call me repetitively to yell at me about things, it got to the point where I didn't want this to go undocumented. And so I tried stating to her that maybe we need to go do this um, over email or over the court has a communication app that they provide that so that way the court can analyze it. And that was a communication that the court option was an option, but it was also stated that I was to cover the cost of all of it, and I could not afford to cover the cost of all of it. And so it resulted in just emails between us. Because during that time that Ezekiel ended up going to the emergency room, um, I answered the phone and I was yelled at. And that's not the first time that it's been the case. And I I don't respond to that style of communication very well, or I just shut down and I feel belittled and I have a hard time with it. And so it did result in us texting back and forth during that point in time with the child care person. Um, I don't agree with how it was stated that I have a history of drug use, which I don't. Even in my drug and alcohol evaluation, drug use wasn't a concern. It wasn't that documented that they felt like that I needed to um, have that I had a history or they need to have observation based off of the situation. Um, it was stated that I used marijuana. I did use marijuana with Natasha in the home, amongst with her family as well. Everybody, it was an open view on the use. It wasn't that um, there was no opposition to using marijuana, and I don't feel like that I at any point put myself or anybody else in jeopardy during the time of my use of marijuana, which I do not use at this current time. Um, On the regard of Elijah and concerns about him and Ezekiel in my care at the same time, Elijah is 8, and he has never shown any eminent concerns in my care to himself, others, or Ezekiel. Uh, he is a child and he has lashed out before, never in a manner that where I felt concerned for anybody, including Ezekiel. There has been verbal communication that Elijah has caused harm to animals, but in my personal experience, the only thing that I have witnessed myself is that he grabbed a dog by the tail multiple times, but he was also 6 at that time, or younger than 6. He was 6 years old when me and Natasha separated. So I don't have anything to say about that behavior necessarily because he was a child and his behavior, I feel like, is not um, a threatening demeanor. So at this time, I'd like the opportunity to have more time with Ezekiel. It's unfortunate that things have unfolded the way that they have because um, right out the gate, I was presented to be this um, heinous individual, and without any ability to look into the past or to see what the situation really was. Decisions were made based off of we're going to take a greater concern and to just in case. And so um, if I was granted more time with Ezekiel, I would be grateful for it. And I've also stated if it was necessary that I take Ezekiel to the doctors. I previously had said that it's, from my perspective, not logical for both parents to take time off of work to go to a doctor's visit. An emergency situation is a whole different story, but to go to a standardized doctor visit, it's not necessary for both parties to take leave from their work, uh, losing that money. Now, if it was necessary that which this is a situation that came up, if it was necessary that I take time off of work so that way she could work, I'd gladly take time off of work so that way she could work. But what it's come down to in the past is that it was requested that I take time off of work for me to go to the doctor's appointment, but she also was going to take time off of work for her to go through the doctor's appointment with me as well. I just didn't find that 100% necessary. If she was already planning on attending the doctor's appointment, why I needed to take the time out of my day to go work. I mean, take my time out of the doctor's appointment when that's money lost, especially when I'm already in the current debt situation that I'm in. And my current financial disposition also reflects the reason why I don't have an attorney in the situation and how I don't necessarily even find myself responsible for her financial obligation to an attorney because she she decided the decision for herself, and that I decided the decision for myself because I knew that I wasn't able to afford an attorney in the situation. Um, there's no viable credit to me having any drug or alcohol dependency issues. On the record, January 18th of 2018, I did sustain a DUI, but upon sustaining the DUI, I checked myself into a treatment facility, had an evaluation done. I did 2 years of treatment. This was not court ordered. This was all on my own to meet the needs of a deferred prosecution, which I currently have held my end on all of responsibilities and have I've tried to be an upstanding citizen since that point in time, not putting myself or anybody else in any jeopardy. I understand that at that time I made a mistake, and that at this current point in my life, I would like to move forward and the past not be a reflection of who I am today. I also would like it to be on the record that I have never left Elijah and Ezekiel alone in my care. I've been with both of the children at all times when they're in my care. I only at one point did I leave Elijah home to go pick somebody up and drop them off. And Elijah was 8 years old and has a cell phone and had all of his amenities that he needed. I've even checked in with him during the time that I was absent from the home, which I did not have Ezekiel in my care at that time. I don't feel like that I did anything jeopardizing Elijah's safety or putting him in any harm during this time. If I felt like that any of these were a possibility, that I would not have went and picked somebody up and dropped them off. So I understand that there's perspective on the situation, but I also know that as a parent that if there was an opportunity for there to cause harm or anything out of the situation that would negatively impact Elijah, that I wouldn't have taken that step. The bigger picture, in my opinion, of this whole situation is that is Ezekiel, and that at this point in time, I am getting him every weekend, one day for an 8-hour visit every weekend. But upon that, I'm also not able to keep a schedule with him because it's a change of environment, and that change of environment, it's not something that he's regular to. And so um, previously to the hair follicle test that was requested of me, I was able to have him on a schedule. We were doing, me and Natasha both agreed to every other weekend. I was getting in for 8 hours on Saturday and 8 hours on Sunday. And upon that schedule, I was able to keep him in a certain routine, and things were working out. But since then, I've had him for 2 weekends, and I was notified and expressed to that I'm not thinking about Ezekiel's best interest because I wasn't able to get him to go down for a nap. Now, if I put him down and he's upset and it's been over 5 minutes, I'm going to go pick him up and I'm going to let him continue to go about his day. And I'm not going to enforce him to sit there and scream because he's upset that he's not tired, because the change of environment impacts him. I'd like to, moving forward, be able to get into a more regular schedule with him. I would also appreciate being able to have overnights with him as well, because I agree upon the foundation of his development in the regard. I'm not necessarily a stranger, but I'm not consistent in his life. And the more time that I get to spend with him, the better it is for his development. It's been in the paperwork previously that I also am not going to be receiving child care or child tax credits for Ezekiel, which I don't quite understand how that abides, because the circumstances are is that I do provide for the child when I have him, and I do provide child care and child um, this child care and child support. And so all things included, my contributions are there. I'm not an absent father in his life. I do feel it's important that um, that I'm viewed as a parent and as responsible as much as the opportunities given parent to Ezekiel, and that I don't feel like it's fair to be looked down upon based off of allegations that were made without there being anything credible behind all of this. I understand that uh, there may be situations out there in the world, but those situations don't abide to me. And so there's reflection being taken place based off of, you know, this is something that's happened before, not with myself, but this is something that's happened before. And so we're going to um, take a similar direction as how it's been handled in the past. Yeah, I am currently doing the best that I can for myself and for my children. Um, the world isn't easy nowadays, but I just hope to make improvements to where my children and I are taken care of and provided for the best opportunity I can give them. I don't think I have anything further to say.
All right, thank you, Mr. Geis. Ms. Bliss may have some questions for you. Cross-examination.
Thank you, Judge. Yes, just a few. Mr. Geis, you indicated that prior to this dissolution proceeding, you had previously worked for Great Western Malting. Is that correct?
Yes.
Okay. And that job was in Vancouver.
Yes.
And you indicated that you can no longer work at that employment because of the drive, right?
I couldn't afford the drive.
Okay. And you're currently working in Battleground.
Yes.
Isn't that roughly the same amount of time and distance as your prior employment?
I currently make $5 an hour more than I was making when I worked at Great Western Malting.
Okay, my question was is the distance the same arguably now as it was in Vancouver?
The circumstances are not the same.
Okay, but the fact of the matter is you left Great Western Malting shortly after this proceeding began and drastically reduced your wages. Is that correct?
Can you say that again, please?
Yes. Shortly after this matter began, so when my client filed for divorce, you stopped your employment at Great Western Malting and took a job earning significantly less money. Is that correct?
I had to take the opportunity based off of the current circumstances.
Okay. I want to look, do you have my exhibits in front of you currently?
What would you like me to look up?
What's been marked as exhibit number 4? Looks like your 2022 tax return.
Okay.
Okay. And you've provided me this document through discovery, is that correct?
I believe so.
And it looks like in 2022, your year-end income was $72,557. Does that sound accurate?
Sounds accurate.
Do you believe that this document is an accurate reflection of your wages for 2022?
I believe so.
Judge, at this time, I move to admit exhibit 4.
Any objection to admitting exhibit 4?
No objection.
4 is admitted.
Thank you. So Jacob, or Mr. Geis, excuse me, you had previously earned significant wages at Great Western Malting, and then you left that job to be essentially a maintenance man for the Office 842. Is that correct?
That's correct.
Yeah. And I have provided an exhibit number 8. Looks like all of your pay stubs from Office 842. Do you have that exhibit in front of you?
I have this in front of me.
And do these look like your pay stubs from your employment at 842?
These look like pay stubs from my employment at 842.
Judge, at this time I move to admit what the marked as exhibit 8.
Any objection to their admission?
No objection.
8 is admitted.
So, Mr. Geis, you left employment at Great Western Malting earning roughly $72,000 per year. And with your employment with Office 842, it appears largely your income was essentially cut in half. You were earning $33,000 as of the date of this statement. Does that sound accurate?
Sounds accurate.
And your reasoning for that isn't that you were going through a divorce with my client, but because of the distance of the employment.
Correct.
You're currently working for Apex Mechanical.
Correct.
And what I have marked as exhibit 5 appears to be a letter from your employer. Do you have that document in front of you?
Okay.
And in that document, looks like Tabitha Marsh with Human Resources indicates that you're earning $30 per hour with this employment. Is that correct?
Yes.
Okay, and it also says that you're eligible for medical benefits, dental, vision, 401k, but you're not participating. Does that sound right?
Correct.
And are you aware that I had to subpoena these records?
Say that again.
Are you aware that I had to subpoena these records?
I understand that they were subpoenaed.
Okay. You did not provide me these records, correct?
Understood.
Okay. Judge, at this time I move to admit exhibit 5.
Any objection?
No objection.
5 is admitted.
Looking to exhibit 6, Mr. Geis, do these appear to be your pay stubs at your current employment at Apex Mechanical?
Okay.
Do these look like your pay stubs?
I believe so.
And within these pay stubs, it now indicates you're earning $40 per hour. Is that correct?
Can you please say that again?
Are you still earning $30 per hour, or did you get a raise?
I'm still making $30 an hour.
Okay. Judge, I move to admit exhibit 6.
Any objection?
No objection.
Number 6 is admitted.
You heard testimony from my client that you are roughly $3,600 in arrears in child support and child care. Do you acknowledge these arrears?
I do acknowledge them.
And that my client made various requests to have you pay child care prior to utilizing DCS services. Is that also correct?
It's correct based off of the fact that I told her that I could only afford what I could afford at the time.
Okay. And now that DCS is garnishing your wages, you are paying child support and child care. Is that correct?
It's correct that the DCS enforcement has taken place since I've gotten a change of employment.
You acknowledge the fact that you only communicate with my client via email.
I didn't hear the last part of that.
You only communicate with my client via email, is that correct?
That's correct.
Okay. Do you have her blocked, or her phone number blocked, or her social media blocked?
I only have the phone number situation blocked. She has me blocked over social media.
Okay. So if there was an emergency while Zeke is in my client's care, she would not be able to call you?
She has reached out to me in an emergency situation.
Okay, let's talk about that. In your testimony, you indicated that you didn't believe that it was financially logical or feasible for both parents to attend medical appointments, but you specifically said an emergency situation would be a different story. Do you recall that testimony?
I recall that.
Okay, you heard testimony from my client that there was an emergency situation, that you were called out from the emergency room and you declined to come to the emergency room. Is that correct?
The circumstances were that I was going to go, but the thing was is that I was getting scrutinized based off of the situation. And so my attendance turned into lacking because of the situation. I asked if it's necessary that I be there, that I'd be there.
Okay. So you don't attend doctor's appointments for your child, you don't appear at emergency rooms when your child is in the emergency room. Is that correct?
Not 100%.
So you have appeared at doctor's appointments and emergency room visits?
I have appeared at a doctor's appointment.
One singular doctor's appointment throughout your child's life?
And I also have stated that I would go, I've stated to the court and I've stated to the petitioner that I would attend these upon request, but I don't find it necessary that both parties take the time off of work to go to a doctor's visit. I personally will go to a doctor's visit, but I'm not saying that it's necessary for both parties to lose wages over the situation.
Have you ever offered to take your child to a doctor's appointment so that my client didn't have to lose wages?
Yes.
My client has offered additional time when there have been issues with daycare and babysitter providers to which you've refused. Is that correct?
Say that again.
Okay. My client has offered additional time outside of the parenting plan when she's had babysitter or daycare issues, and you have declined those visits. Is that correct?
No.
My client has never offered you additional time and you've never said no.
There's potential that at a particular time it may not have worked out, but it doesn't mean that it's a reoccurring situation.
You've never had Ezekiel overnight.
No.
Arguably, you've never had him over an 8-hour period of time by yourself.
Unfortunately, no.
Okay. There were some discussions in your testimony and in my client's with some issues with your visitation with Ezekiel, primarily as it relates to nap times and maintaining his routine. Do you acknowledge the fact that there's issues with his routine while in your care?
There was an issue with Ezekiel abiding to taking a nap to a situation, and I did not impose putting him through an upsetting state given the circumstances.
Are you aware that Ezekiel takes a nap every single day?
I'm aware that Ezekiel takes a nap.
Okay. And you acknowledge the fact that while in your care, he does not take a nap?
These last 2 weekends, yes, that's the circumstance.
Prior to that, you took naps while in your care?
Yes.
Do you know what Ezekiel's schedule is?
The scheduled time that I get him currently, our agreed upon hours is 9 a.m. to 5 p.m.
I'm asking, do you know what Ezekiel's routine is? When I say schedule, I mean routine.
His current routine? No.
Okay. So if you were to have him in your care beyond the time that you currently have him in your care, you wouldn't know when he wakes up, when he goes to sleep, when he takes a nap, when he eats, any of those things?
These are all variables.
So is that a yes or a no that you don't know his schedule?
I don't know what his schedule is with Natasha's time. His schedule is not going to 100% abide during my time.
Okay. Do you think it's, for lack of better words, good for a child to have varying schedules in various households?
To my acknowledgement, circumstances being that it's a split household, his routine may be similar and it may be different.
Earlier in this case, you were required to have an alcohol evaluation. Do you recall doing that?
Yep.
And you completed that alcohol evaluation?
Say that last part again.
And you completed that alcohol evaluation?
Yep.
Okay, and the evaluator indicated you were high risk for relapse, is that correct?
I don't believe so, but if you have documentation that says that I was high risk, then yes.
Okay, we've filed the evaluation with the court previously, is that correct?
I believe so.
You indicated in your testimony today that you were arrested for a DUI several years ago, correct?
This was also submitted to the courts.
Okay, so I'm just trying to get a history here. You indicated to the court that there's been nothing to substantiate any allegations that my client has that you have a drinking issue, is that right?
There's nothing currently substantiating the situation.
Okay, but you have a history of alcohol use and abuse.
There's one documented event.
Okay, you testified yourself today that you got a DUI and you checked yourself into treatment for that DUI, is that correct?
Say that again.
You testified this morning that you were arrested for a DUI and you completed treatment for a deferred sentence for that DUI, is that correct?
Yes.
Okay, even after having a DUI, you continued drinking while in a relationship with my client?
No.
You did not drink at all while in a relationship with my client?
I'm an adult and I'm entitled to have a beer at my leisure.
Okay. You heard testimony from my client about a 4th of July incident. Do you deny that that occurred?
Deny what?
That you were blacked out drunk on a fifth of peanut butter whiskey and then proceeded to mix tequila and energy drinks?
I deny the statement.
You deny the statement, but you don't deny that that actually occurred?
I deny it.
Okay. You're still drinking to this day?
Nope.
You didn't acknowledge to my client that you're continuing to drink?
So let's not get this confused. We're talking about excessive drinking comparatively to casual drinking. To me, have a beer is not something that's uncommon amongst people.
Okay.
Now, do I have a beer occasionally? Yes.
So for someone who's been evaluated by an alcohol evaluator, did not recommend treatment, but also indicated you have a high risk for relapse and you're continuing to drink, is that correct?
So my statement, even during my evaluation, persisted of me saying that I drink a beer occasionally.
Okay. So you still drink, that's your testimony. Do you ever drink while your children are in your care?
No.
Okay. You indicated in your testimony that you left Elijah, who was 8 years old, alone while you went to pick somebody up, is that correct?
That's true.
And you picked this person up and were at a bar, isn't that also correct?
Yep. I went and picked them up and just dropped them off and I went back home.
And is there a reason why your child couldn't accompany you during this time?
Because I wasn't going to impose my child to be around the influence.
Has your children ever seen you intoxicated?
No.
Okay. You testified, and you heard my client testify that you historically and or currently use marijuana. Is that correct?
Historically,
Okay. You don't currently use marijuana?
no,
Okay. Have you ever smoked while your children are in your care?
no,
Your children have never been exposed to you being intoxicated on marijuana?
no.
Did you not testify or at least state in the most recent hearing with the request for the hair follicle that you were continuing to use marijuana?
I'm not continuing to use marijuana. At my current employment that I've been at for 4 months now, I do not, it's not accepted that I use marijuana at my employment.
Did you not provide your analysis reports for that employment pre-drug screening that had positive for marijuana?
Those were my initial drug screens through the company. And so previously I did use marijuana.
Okay. I want to go back to Ezekiel's care. You're aware that Ezekiel currently sees a speech therapist?
I'm aware.
Okay, and you were notified by my client giving your number to the speech therapist to communicate with you directly, is that correct?
I acknowledge this.
Okay, and you asked the speech therapist to stop contacting you, isn't that also correct?
Nope.
And you admonished my client for giving the speech therapist your phone number, isn't that correct?
The circumstances to the situation was that I told her that not to be just giving my phone number out to anybody and everybody.
Anybody and everybody, meaning your child's care providers?
If it was agreed upon, that would be the necessary attempt.
Wouldn't that also require you to be involved in your child's medical care for that to happen?
And I am involved with it. She has the opportunity to communicate with me.
Did you know your child needed speech therapy before he was enrolled in speech therapy?
It was conversated, that was the circumstance.
Since it's been addressed already that you don't attend medical appointments, how are you aware of what your child's medical needs are?
If it was communicated with me, or if I was given the opportunity to go to a medical appointment with him, based off of how I previously stated that it's not necessary that both parties take time off of work to go to a doctor's appointment, I would attend the doctor's appointments.
Have you ever contacted his doctor to get an update as to his medical records or care?
No.
Do you even know who his doctor is?
Yes.
Isn't it true that you frequently switch days for your visits with Elijah so that you can work on the weekends?
With Elijah?
Or Ezekiel, excuse me.
It's become an opportunity where I asked for it to be the situation, and it worked out in that favor, yes.
Okay, so you're voluntarily not exercising time with your child so that you can work?
Given the circumstances, I asked for the opportunity and I was granted the opportunity, yes.
Okay. But it's your request today to have additional time than what's currently ordered, yet you're not even exercising that time.
The exercise of time was based off of circumstances. If I was denied the opportunity to switch days with her, then I would have taken the current time.
Okay. Do you have any clothes for Ezekiel at your house?
Yes.
Do you have a bed for him?
Yes.
Have you provided any of that documentation to my client or the courts?
I didn't know it was necessary that I provide documentation of clothes and or a bed.
Okay. Is it true that Ezekiel sleeps in a playpen while in your care and not a bed?
So I have a bed and I have a playpen.
Okay. Let's talk about the lifetime of this case. My client filed for the divorce, is that correct?
Correct.
Okay. And I've been involved throughout the entirety of this litigation.
Correct.
There was significant attempts by my office to get you to comply with discovery. Is that correct?
I wouldn't necessarily phrase it significant, but there was attempts, yes.
Okay. There were several meetings in my office with me personally, with you, trying to get discovery. Is that correct?
I was doing my best to try to get you the paperwork that you would need.
Okay. There were threats for a motion to compel. Is that also correct?
There were threats, motion to compel. What does that mean?
There were threats that I would file a motion to compel to get you to comply with discovery if you did not provide me the documentation.
I guess. I
Okay.
tried to do my best.
Sure. I had to subpoena your most recent employment records from your previous employers and your current employer.
Okay.
Okay. You did not attend the mandatory settlement conference.
I unfortunately missed it.
Okay. I made several different attempts between then and now to resolve this case with you. Isn't that also correct?
I also reached out to you.
Okay. At no point, whether it's to the court or to me, have you ever provided your position to finalize this matter?
I wanted the opportunity of the court to hear the situation as a whole instead of it just being shorthanded.
And you understand that with all of those attempts and with forcing this matter to go to trial today, my client has incurred significant attorney's fees.
It's the client, your client's option to have representation to the situation.
Isn't it also true that throughout this entire case, you've never pressed this matter forward to finalization?
Based off of all of the allegations, like I previously stated, that I wanted the court to have the opportunity to see the situation as a whole.
So, but for my client and or her attorney, this matter would never have been finalized. Fair to say?
Say that again?
But for my client and myself, this matter would not have come to trial or be finalized. Isn't that fair to say?
Yeah, it wasn't necessary that it go to this far into going to a trial.
Okay, but you also acknowledge that you failed to participate in any settlement discussions.
Say that again?
You said that it didn't have to come this far to a trial, but you're also acknowledging that you failed to participate in any settlement discussions.
Me and the petitioner had the opportunity to go over things together without having to push further into the courts.
Okay. I'll move on. You've already been ordered by the court to pay attorney fees, is that correct?
Based off of my one missed hearing, yes.
Okay. And you have not paid those to date?
Currently still trying to figure it out.
You were found in contempt earlier on in this case, is that also correct?
I was in contempt?
Yes.
For what matter?
Back in February of this year, the court found you in contempt for failing to pay daycare expenses. Is that ringing a bell?
And it was I previously stated that in the current circumstances, I wasn't able to afford them, so I was held in contempt, yes.
Okay, and the court ordered at that hearing that you not only pay arrears for childcare, but also attorney's fees. Do you recall that as well?
Attorney's fees for what?
For having to bring the motion to get you to comply with the court order. Do you recall that?
What was the only attorney fees that I'm aware of was this last missed hearing when we're supposed to do that, not mediation, but where we sit down and talk to each about things.
Okay.
I wasn't aware of previous attorney fees.
Okay, so you weren't aware that at that contempt hearing on February 14, 2023, the court ordered you pay $500 in attorney fees?
I wasn't aware of the $500 attorney fees.
Okay, so at this point, you owe my office $1,500 in attorney's fees for my client's preparation for a contempt motion and the settlement conference to which you were ordered to pay fees. Do you acknowledge that?
Understood.
Okay. Judge, at this time, I have nothing further.
Okay. So it's your turn again, Mr. Geis. This is what we'd call your redirect examination of yourself. So if there's additional information you'd like to share, go ahead, please.
So I'd like to look at my most recent pay stub for Great Western Malting. My last pay stub.
Do you have a reference? Do you have a document number that I could look at?
I'm trying to look it up right now. Oh, it's not in the paperwork, and I didn't file it, so I'm not sure that's going to be something that's going to be able to be used. But my employment, my employment with Great Western had variations to my pay, and so in the last few months that I worked for Great Western, so there was a reflection that I made $70,000 gross in the I think 10 months that I worked there. But the circumstances are is that I made substantially more at the beginning of the year towards the end than towards the end of the year because me working for Great Western it's a malting facility. It makes malt for beer. Well, there was an economical change which happened towards the end of the year, which got my hours cut back, which my paychecks working for the company changed drastically, so that it was stated that I chose to leave this job that I made $70,000 that year. At that point in time, when I decided to leave the company, I was only making $1.50 more an hour working for the company than I was making working for the Office 842. Now, it's quite understandable that if it was consistent throughout the whole process that I was making the money that led up to me having earnings of $70,000, that why would it be necessary that I change employment? But that wasn't the case. And so I want it to be noted that variations did happen. Things did change. And so I made the most appropriate decision for myself at that time. That's all I have to say.
Okay, all right, thank you. ReCross, Ms. Bliss.
Yes, Your Honor, just on that one issue, Mr. Geis, I'd like you to turn to what I marked as Exhibit 11. At the top, it should say employment security data. Let me know when you have that in front of you.
I'm not seeing exhibit numbers. Okay, employment security data for.
It should be your name in the top left-hand corner.
Okay.
You have that? Okay. So if you look at section number 2, where it says Great Western Malting Company, do you see that?
Yep.
Okay. And on the right-hand column, it says quarter 22-4, 22-3, 22-2, 22-1. Do you see that?
Yep.
Okay, so it was just your testimony that you earned more earlier in the year and tailed off later in the year, and prior to leaving your employment, you were kind of in a lull. Is that accurate to say?
So in the fourth quarter of 22, there was an influx. So I guess the third quarter, not so much, but the fourth quarter, there was a lull in production. And this quite makes sense. It's 23 right now. 22 was last year. How did I work the fourth quarter of last year? Okay. So yeah, there was, yes, that was the circumstances. There was a lull in production and hours got cut. You can see how um, the previous quarter I made 20,671.55, but then the fourth quarter I made 19,584.15, and it was going to consistently drop because it was, um, to my perspective, about halfway through the year or through that quarter is when things, the influx started happening. So at that point in time, I wasn't able to, based off of both not having a shared income household and me being able to afford everything on my own. Uh, Equivalently, that the influx in pay happened, that I had to make a decision based off of the circumstances. I even communicated with my employer saying that I needed uh, particular opportunities for me to be able to keep my job of employment because I had such um, because I had many things to look forward to be able to stay with the company with all the benefits and stuff like that. I didn't I didn't want to leave the company, and at that point in time I did make the decision based off of what I had to do.
Okay, so you acknowledge that this document indicates that you made $16,301 the first quarter, $15,093 the second quarter, $20,671 the third quarter, and $19,584 the fourth quarter.
This is accurate.
Okay, and then turning to the Office 842, whom you left that job for to go to, you earned $2,424 in the fourth quarter. I'm assuming you had just started your employment late in that quarter. But looking to the 2023 first quarter, you earned $12,348. Is that accurate?
And their accuracy to the situation is that in the quarter is 3 months. And so in 1 month, I was spending $500 a month in gas. And so that's $1,500 difference. And so it does have a slight reflection of that not being 100% logical. The way of the circumstances are is that even upon me losing my vehicle, the job, the Office 842, because I didn't know what the financial disposition was turning into. Upon me losing my vehicle because it's a loan, the job was within walking distance of my home.
And
So
one
I
last,
acknowledge.
oh, it's okay. One last thing, you worked substantial overtime at Great Western Malting, isn't that also correct?
At a point in time, yes, I was working substantial overtime.
Okay, thank
Towards
you.
the end of it, no, I wasn't.
Thank you.
What?
Okay, all right. That concludes the testimony of Mr. Geis. Thank you. Mr. Geis, would you like to call additional witnesses?
No.
Okay. All right, thank you. Ms. Bliss, any rebuttal witnesses?
No, Judge, I still rest.
Okay. All right, so that takes us to the end of, that's the end of the presentation of evidence. So now we're at the stage of the proceedings where it's closing arguments. This is where each party has the opportunity to summarize their argument based on the facts presented today and argue why those facts support your position and what you're asking for. So I'll turn the time to Ms. Bliss for closing argument, and then we'll hear from Mr. Geis.
Thank you, Judge. Judge, you've heard testimony from my client and Mr. Geis this morning. I think both parties have provided substantial information to the court regarding obviously the biggest issue of this case, and that's the care of Ezekiel. What you've heard from both parties is that it's been no contest that my client is the primary parent of Ezekiel and has been the entirety of his life. Father's interactions with Ezekiel have been minimal, whether that be by choice or by employment, but there wasn't even a contest as regards to his participation in the care and the upbringing of Ezekiel. You heard testimony from both parties that even in an emergency situation, father refuses to provide care for Ezekiel and fails to even come to the emergency room. You heard testimony from both he and my client that he does not get any information as to Ezekiel's care unless my client provides it. He's never sought out the information upon being contacted by a provider. He said, "Stop contacting me." So that speaks volumes as to his ability and willingness to participate in the care and upbringing of Ezekiel. The information that's been provided to the court, in my opinion, suggests that my client's proposed parenting plan is in Ezekiel's best interest. You've heard from both parties that Ezekiel has never spent substantial time with Mr. Geis, has never spent more than an 8-hour period with him. Obviously, if the court is going to make a determination as to a parenting plan as we move forward, I ask the court to take great consideration to that fact. The fact that Mr. Geis, during the relationship and even after the relationship, primarily put the responsibility on my client, and that is the parent in not only her testimony, but in his as well. The financials kind of speak for themselves. Mr. Geis acknowledges the fact that his prior employment, prior to this dissolution beginning, he earned substantial income, worked substantial overtime, and then took a job in town with significantly reduced income, earning significantly less, and we argue that was intentional, and that was for purposes of reducing his child support obligation. So for purposes of child support, my client's proposals are taking her actual income and what Mr. Geis should be earning. It's great that he's taken on employment down in Battleground now, making substantially more than he was making with the Office 842, but his behavior speaks volumes. Looking to the asset and debt distribution, I didn't hear anything from Mr. Geis contesting our proposals, so I would ask that those be entered as they've been presented. I believe that those are fair and equitable. I believe my client has provided substantial information to confirm this with the court. And lastly, as it relates to attorney's fees, you heard some substantial testimony not only from my client, but Mr. Geis as to the timeline of this case, who kept pushing the ball closer to the finish line, and that was my client. And she had to bear substantial attorney's fees to that regard. We did provide you a affidavit of attorney's fees for the costs that she has incurred up to date, and presumably through the end of getting this matter finalized. We're looking at nearly $13,000 for a case that arguably could have been resolved straight out of the gate, or additionally at the mandatory settlement conference had Mr. Geis participated. My client is largely a single mother at this point. You've heard that there's been substantial fights to get child support and child care paid by Mr. Geis. So not only is she fronting nearly 100% of the cost to care for Ezekiel, she's fronting 100% of the cost to get this matter finalized. So I ask the court to take that into consideration as well. With that, Judge, that concludes my argument.
All right, thank you. All right, Mr. Geis, closing argument, please.
Pertaining to that last bit of it, it's not 100% true to say that Natasha's fronting the bill on all of this when my contributions are being paid. You know, it's not like I'm still haven't paid anything towards child support and she's completely footing the bill. I understand what child support is supposed to be for and what child care is what it's supposed to be for, but I want that to be taken in consideration that my contributions are involved, and that based off of the way that the case has been moving forward, there's been some steps forward and steps back throughout this whole process, and what it comes down to is agreeing or disagreeing upon things. And so at several points in this process, it's been addressed to me that I just need to sign it the way that it is, and because I don't agree to the way that it is, now it's going to continue forward because I can't just agree to something that I don't agree to in the matter. As far as Ezekiel and my opportunities with him, I've been limited to being able to have time with him, and I would be grateful to be granted more opportunity and time with him, because that at that point in time, it would be alleviating responsibility off of Natasha and would also give me the opportunity to developmentally progress with Ezekiel, both uh, um, my own personal maternal level, educational level, um, doctor's visits, or anything else along those lines. That it's a lot more common nowadays that fathers are granted more time with the children comparatively how it was in the past. And I would like the same kind of courtesy to be able to give Ezekiel the most of an opportunity that he can have. And all things considered, I think that's really what my closing statement has to be.
Okay. All right. Thank you, Mr. Geis. All right. So just taking a look at the time frame, we're a little bit after 11:30. I have a meeting that'll run for about an hour and a half, starting at noon. So I want to take more than just 25 minutes to review my notes and look at the exhibits and the like. So what I'm proposing, if the parties would be available I don't know if you're available today at 3 p.m. to come back on the Zoom call at 3 p.m. and I can give you my decision at that time. So just want to touch base with the parties to see if that's a workable hour. Ms. Bliss?
Yes, sir, that works for me.
Okay. And Mr. Geis, how does that look?
Yes, sir.
Okay. All right. So we will use the same link that we used to conduct the proceedings this morning, and we'll reconvene today at 3 p.m. and I'll give you my decision on the issues presented at that time. So before leaving, just thanks to all the parties. I appreciate the manner in which you all conducted yourselves today. Going through this is not an easy process. It's hard, it's challenging, and I just appreciate the way that each of you conducted yourselves. So thank you. So I'll go ahead and sign off, and then we will reconvene at 3 p.m. this afternoon.
Thank you, Judge.
Okay, welcome everybody. Thanks for your punctuality and thanks for the patience and allowing me a little bit of time to gather my thoughts and share my ruling. So with regard, I'll just jump right in. So with regard to the debt distribution, there was information presented by Ms. Geis related to the debts, the varying debts and the varying assets as of the date of separation. None of those were contested. They were supported by bank statements and the like. And so I'm going to go ahead and adopt those as presented. And so specifically, so everybody knows where we're at, the Silverado obviously stays with Mr. Geis, the Chevy. The Red Canoe savings account ending in 746 that has a balance of $5 that goes to Mr. Geis. The Red Canoe checking account ending in 746 with a balance of roughly $310 goes to Mr. Geis. The pension or 401k through the Teamsters or what have you, that goes to Mr. Geis also. As far as property for Ms. Geis, the Hyundai stays with her. The Red Canoe checking ending in 027 of $5 goes to her. The fiber account, which is divided in two, one's checking and one's savings, ending in 0922. Checkings in the amount of 1,018, savings is in the amount of 1,005. Those will each go to Ms. Geis. And I just saw Mr. Geis adjusting your earpiece. Have you been able to hear what I've been saying?
Yes.
Okay, great. All right, very good. So when you add up those balances, that sets Mr. Geis's property balance at roughly $33,230. And that sets Ms. Geis's balance at roughly $29,547. As far as the debts, the debt associated with the pickup, the Silverado, that goes to Mr. Geis. He'll be responsible for that. The upgrade credit card as of the date of separation, that's the account ending in 8191. And the amount of $1,903 will be assigned to Mr. Geis and will be his responsibility. The PayPal credit card ending in 1786 in the amount of $80 will be assigned to Mr. Geis, as well as the Sunbit credit card ending in 2431. That's in the amount of $1,795. The Capital One ending in 9036 with a balance of 954 will be assigned to Mr. Geis. The the Credit One credit card ending in 7492 in the amount of $572 is assigned to Mr. Geis. The Credit One credit card in the amount of $367, the account ending in 5360 is the responsibility of Mr. Geis. The Target red card that is in Mr. Geis's name, that'll continue to be his responsibility. As far as debts to Ms. Geis, there's the Hyundai loan. She'll be responsible for that. The Target red card, which ends in 1711, date of separation, the value is $4,104. That'll be her responsibility. The Amazon Prime card ending in 9484, in the amount of $694 is Ms. Geis's responsibility and is assigned to her. The Fiber Visa card ending in 0922, in the amount of $4,117 is assigned to Ms. Geis. And any other credit cards that were in her name but not listed therein, and that was assigned to Ms. Geis, and the same applies to Mr. Geis. So those balances roughly for the debts to Mr. Geis total roughly $35,540, and the debts assigned to Ms. Geis are $44,314. So when you add the positives versus the negatives, Mr. Geis comes with a shortfall of 2,310. Ms. Geis comes up with a shortfall of 14,767. So I'm adopting the balance sheet as presented by Ms. Bliss. Before I go further,
Pardon me.
yes, sir.
Pardon me, sir. What does that mean?
That's basically assigning the values of the debts as of the date of separation. So each party is responsible for those debts, and they're divided up. So if there's any question whether it's Mr. Geis's or Ms. Geis's or the community's or somebody else's, I've assigned who's responsible for those particular debts. Does that help?
Yes, sir.
Okay.
Thank you.
Sure. Then before I go further, the clerk asked me to just inquire of Ms. Bliss regarding several exhibits that were not presented, and she wants to know if you're seeking those to be withdrawn, and they are specifically Exhibit 3, 7, 9, 10, and 11. So 3 is
Yes, Judge, I have no problem with withdrawing those at this time.
Okay, all right, so those will be withdrawn, 3, 7, 9, 10, and 11. All right, thank you. Then back to where we were. One moment. So let me just jump right into the parenting plan. With regard to the parenting plan, here we have a child, Ezekiel. Zeke, as it sounds like he's often called, is now 2 years old, and it seemed to me that there was a fairly clear division of responsibility within the family between Mr. and Ms. Geis. Mr. Geis was in charge of principally financial responsibility. He was working long hours, 12-hour days with about a 2-hour commute to and from work. So a lot of the burden of caring for little Ezekiel fell upon Ms. Geis. So, and I agree with definitely agree with the proposition that when we have a child who has both parents that's actively involved in their family, actively involved in their life, that's obviously in the best interest, barring any other factors, in the best interest of the children, to have those two involved parents. So what I saw from the evidence that was presented today is that Ms. Geis has shown significant and steady dedication to Ezekiel by the giving of her time and energies directly. And Mr. Geis also has shown his dedication by working to supply income to meet the needs of the child. And I also find it's important to note that children obviously are multifaceted individuals. They need physical needs. They need their emotional needs met. So they need more than each parent, roughly. In that their income earners should be in a place, even though it's a challenge when you're working long hours, to give more of themselves, maybe emotionally and with time and the like. And I think that the evidence that showed there was more of a narrow focus for Mr. Geis as far as the financial support. He's very focused on that, and not improperly so. And however, that came at the detriment of providing more of the actual hands-on physical needs and also the emotional needs of Ezekiel. And the evidence pointed out that the medical appointments were kind of a telltale sign of that, where Ms. Geis was the one who went to those appointments. And that was, that's a form and function of the division of responsibility within the family, is that Mr. Geis felt it was very important that one of the parents continued to work while the other one took the child to the appointment. And it sounds like Ms. Geis attended all of those. Mr. Geis attended one of those. Also, I think the emergency room visit, well, obviously that's a very distressing event when a child falls. That Ms. Geis was the one that went and took the child, obviously because she was with the child. However, when Mr. Geis was given the opportunity to come and be there, not only maybe just an emotional support to the child, but to be present and be eyes and ears and hear what the doctors and medical professionals are saying or talking, and kind of coming to his own conclusions and not necessarily delegating that responsibility out. I think that kind of shows where the parties are at mentally as far as caring for the needs of the child. So I think that what that tells me is that there is a request for a finding of neglect. I'm going to make that finding as to Mr. Geis. I think that is supportive of that. Related to the communication here, I think the communication is very strained between the parties. Mr. Geis has indicated that he prefers email communication because that everything's documented, and the Family Wizard app, or the app that was mentioned earlier in the testimony, is cost prohibitive. Therefore, he opted for the email. And again, here when there was information related to the well-being of the child, it sounded like the child caregiver made contact with Mr. Geis, and Mr. Geis indicated that he doesn't like to be yelled at, and so he wasn't going to do that, and so that the communication then was through text during that time. So what that tells me is that there's some pretty significant difficulties of the party communicating, even in times of emergency. So I think it's in the best interest that when the child has emergent medical needs, that sole decision-making is given to Ms. Geis. So as to medical, I'm giving sole decision-making as to the child, to Ms. Geis. Education at this point, child's 2 years old, pretty hard to say what's going to happen in the future. So as far as education, I think education tends to be maybe a slower moving target. And so therefore I'm going to make that joint decision-making between the two parties. I'm just going to make just one quick note to myself.
Pardon me.
Yes, sir.
So you found it right that the opt for neglect was suitable based off of my not attending doctor's appointments?
That was one of the factors, correct?
Okay.
So therefore, regarding there were concerns related to alcohol and drug abuse. I heard information that Mr. Geis had a DUI and went through a deferred prosecution, or is still involved in a deferred prosecution, not quite sure of the status, but had an evaluation related to that. So I know that sometimes when a judge is giving a ruling, there's desires to fill in gaps. The opportunity to fill in those gaps has passed, because when each party rested, that marked the end of the giving or presenting of testimony. So I'm basing my decision based on the evidence that was elicited and given during the trial. So while I may not know the specifics, I think I have a fairly good idea of what was related to at least the DUI. There was a DUI, it happened, there was a citation, deferred prosecution happened, and that Mr. Geis indicated they went to treatment and the like. I also know that there was an evaluation conducted that indicated that recommended no treatment, and also indicated that there was a high risk for relapse. So with that, the parties have been using a fairly limited schedule of visitation, where Ms. Geis is the primary custodial parent and Mr. Geis has visitation or residential time each weekend for a period of 8 hours continuous on either Saturday or Sunday. So here, I don't see any reason to disrupt the pattern where Ms. Geis is the primary residential parent I think the parties have made that decision themselves previously, and I think the evidence presented at trial bears that out and supports that. Here, I think it's Mr. Geis has indicated that he wants to have more time with his child. I think that's important, and I recognize that, and I think all parties recognize that having two parents involved is very, very, very important for the well-being and best development of Ezekiel. So, and I also recognize also that there has not been, since the child was roughly 4 months old, that there has not been any overnights of the child with Mr. Geis. So I think there's some prudence in moving somewhat slowly and not necessarily jumping up to a real jump up in visitation. So what I'm going to do, I'm going to keep the every Saturday from 9 to 5 p.m. and then on the Sunday following from the same time, and then we're reverting back to the Saturday, Sunday alternating each week, and that'll continue until age 4. At age 4, then the overnight can begin, where on Saturday at 9 a.m. until Sunday at noon, and then that will be on the first, third, and fifth weekends. And then Mr. Geis will have an every midweek visit, Wednesday from 4 to 7 p.m. And I'm not beholden to the Wednesday. If schedules need to be adjusted, if the parties agree in writing, then that can be adjusted to a different date. But that's the court's intent, is that there's weekly, midweek contact between Mr. Geis and his child. So
just because
Yeah.
sir, just because I want to be able to write this stuff down, can you repeat that scheduling that you're ruling on?
Yeah, absolutely. So there'll be a continuation of the current parenting plan of weekly visits for 8 hours on the weekend, either Saturday or Sunday, 9 to 5. And then at age 4, then this the visitation will be Saturday morning. Mr. Geis's residential time starts at 9 a.m. It will extend overnight until Sunday at noon. And that will occur on the first, third, and fifth weekend of each month, as defined by Fridays. And then every Wednesday of every week, there'll be visitation from 4 p.m. until 7 p.m.
Every Wednesday?
Wednesday, correct. And if that interferes with scheduling, one party, I've worked till 6 on Wednesday, can we move it to a Thursday or to a Tuesday? As long as the parties agree in writing, that's great. If you can't agree in writing, then the default applies Wednesday, 4 to 7.
4 to 7.
Right.
And then the Saturday to Sunday is starting at 4, the first Sunday of what? Or the first Saturday of what?
Yeah, that occurs when the child turns age 4. So when the child turns age 4, then the next Saturday, if it's the first, third, or fifth weekend, then it'd be Saturday at 9 a.m. until Sunday at noon.
And I don't mean to speak out of turn, but Mr. Geis, you will also receive, once I prepare, this is an oral ruling, and then I prepare physical orders to the effect, so you'll receive those as well. So don't be concerned about making sure everything's written down. Sorry, Judge.
Yeah, it's good, and I appreciate that the summary will be forthcoming, and that Mr. Geis has an opportunity to write it down right now from the horse's mouth, if you will. Okay. Then I also wanted to make mention related to, there's a request for an alcohol or marijuana restriction, basically no consumption of either of those substances 12 hours prior or during the residential time of Mr. Geis. I think that's warranted. Here, the testimony has showed that there had been an issue related to alcohol connected to the DUI. There was some evidence related to the July 4th incident about excessive drinking. And then there's concern for the high risk of relapse and continued consumption of beer, as Mr. Geis had indicated. So I will apply that restriction as presented. I think that's appropriate. Then I wanted to double check with one thing with the parties. On the proposed order, there was a request that Mr. Geis be evaluated for substance use disorder with collateral input from the parties. And I know that there was an evaluation that was done in the not too recent past. I don't know how far in the past it was. And so I just need a little input from the parties. Mr. Geist, do you remember when that evaluation took place?
We separated in March of 22. The evaluation might have taken place in around October of 22.
Okay, so just slightly over a year ago.
I believe so.
Okay, and then Ms. Bliss, do you know if there was collateral input from petitioner or any GAL?
There was, Your Honor, and upon reviewing my proposed parenting plan, I think that was just simply left in from the proposed parenting plan brings, and was inadvertently left in, so I would ask to have that removed at this point, since he's already completed that.
Okay, yeah, that should be omitted from the parenting plan, so I'll strike that. One moment. Okay, thanks for addressing that issue with me. Let's turn now to child support. I think that Ms. Geis's income is fairly straightforward, pretty easy to determine based on the pay stubs that were presented. She earns a gross of $3,759. She has a net of roughly $2,736. So there was some concern expressed by Ms. Geis related to Mr. Geis possibly taking a lower paying job. I took a look at the employment security data, and what it showed me is that Mr. Geis has a fairly consistent pattern of frequent job changes. I think we go back roughly 7 years, back to 2016, he's had 13 different jobs. So that's roughly 2 jobs per year. So he has a pattern of changing jobs. So it doesn't seem like that's unusual that he would change his job, other than at Great Western, he was making more money than I think he had made in any other employment security data reported job. So he indicated, Mr. Geis indicated that he indicated that the cost of the gas to the commute was significant and was a factor in his job switch. Maybe not so much the distance, Battleground, Vancouver, the like. And he indicated that taking into account the cost savings of not paying gas, maybe even wear and tear on a vehicle, resulted in roughly a net difference of $1.50 an hour between the 2 jobs. However, when I look at the Great Western employment security data, Mr. Geis had indicated that there was a slowdown at the end of the year, and he was earning significantly less, and that was kind of motivation of, the malt industry didn't need as much malt, and so things were slowing down. He wasn't getting the hours. The numbers indicate otherwise. They show roughly that there was a dip in the fourth quarter, but by roughly about $1,000 over that quarterly period. So not a huge amount, but fairly high wages at that point still. So that showed me that there was roughly an average of $42 an hour for the 10 months that he was working there, versus the $25 an hour that he started earning at Office 842. So that gives some traction to the argument by Ms. Bliss's client that Mr. Geis had changed his jobs to potentially lower his child support obligation. And I note that at prior to Great Western, he wasn't earning as much as he was at Great Western. That was a good paying job. And now he's making a wage that's more historically in line and more reasonable with what he had previously made, although it appears to be slightly higher at that $30 an hour. So that's the figure I'm going to use. I'm not going to impute him at the higher Great Western wage. I'm not going to do that. I'm going to use his current wage of $30 an hour with all the tax withholdings and the like removed. And so that's what his hourly, his net income should be based on. I will apply the whole family deviation, as Mr. Geis is supporting Elijah, his other son. So that whole family deviation should also apply. So let me just double check that. I think the next item is attorney fees. Here there's a request for attorney fees from Ms. Geis, and her argument is that she's the one that's been pushing this case along, and if but for her pushing, this case would not be at trial and would be very difficult to resolve. And that has some merit to it, in that the evidence has shown is that there's been some resistance by Mr. Geis as far as participating in discovery, there was a finding of contempt related to that, and also a non-participation in a mandatory settlement conference, which is a great off-ramp. If the parties they come together and potentially work on, maybe not all the issues are resolved, but at least maybe some of them can be resolved. And there was non-participation there. Also, I think a telltale sign of resistance is the fact that subpoenas had to be issued for employment records. Employment records generally can be obtained by the employee or the former employee by a mere request of that individual and then turned over. But here there was an added step that was required. So I think that there's those two bits of evidence that I look at is that but for the involvement of Ms. Bliss and her familiarity with the system to push cases along and get cases resolved, and the indication that Mr. Geis was somewhat resistive to the process itself with specific examples, I'll award attorney fees of $5,000. It's not quite an equal split, but it's a little more, it's less for Mr. Geis than it is for Ms. Geis. So that's the court's orders. So I'll ask any party if you have any questions or clarifications related to the court's ruling.
Yes, Judge, just a point of clarification, when you were discussing the, I'm assuming you were in the parent plan at the section 3B, you started talking about some Mr. Geis's alcohol history, the DUI evaluation, and then we kind of trailed off into the residential schedule. I wasn't sure if you were making a finding of substance abuse within that section.
I'm not. I'm striking substance abuse finding. I'm not making that finding. I think there's concerns that are manifested by the restriction on consumption before and during, but I'm not making that finding.
Okay, very good. The issue of the tax exemption, we had made that request.
Yeah, thank you. I appreciate that. With regard to the tax exemption, let me pull up my note on that. So this is in the proposed child support paragraph 19. The argument from Ms. Geis is that there's a shortfall based on childcare and the like. Mr. Geis is also, and also Ms. Geis is, with the child a significantly larger period of time. So there's an argument that there's maybe greater resources being spent to care for the child. Mr. Geis indicates that, hey, I'm also paying child support that's supporting this child. So I'm going to make it equitable. In odd years, Ms. Geis has the right to claim Ezekiel. In even years, even tax years, Mr. Geis has the right to claim Ezekiel, and that should be conditioned upon Mr. Geis being current in his child support for that even year, tax year, by the January 31st of the year following. So let's say 2024, if Mr. Geis has paid all of his child support for 2024, and we know that by January 31st of 2025, then Mr. Geis can go to his 2024 tax return and claim Ezekiel for the tax year 2024. So that should be included in the order.
Very good. That's
Pardon me.
Okay.
Mr.
Geis.
So I'm able to claim him on odd or even years,
You will
providing
be
conditions.
You will be even. You will be even years. Ms. Geis will be odd years. So 2023 will be Ms. Geis. Ms. Geis's opportunity in 2024 will be yours, and then I'll just flip-flop thereafter.
Okay.
Any other points of clarification? Those are very helpful questions. Thank you. If not, there's a couple of orders that probably need to be modified slightly, and that Ms. Bliss will prepare, and she will forward a copy to you, Mr. Geis, of those changes that the court ordered here today. And then if you have objections to those, or meaning that the court didn't order that, or Ms. Bliss interpreted that incorrectly, then we'll set a presentation date so you can present those objections. So let's take a look at the calendar and choose a date for that purpose. So with the holidays, I'm not sure, Ms. Bliss, if you're the one that's going to be preparing those orders, what your timeframes are. Next week is Christmas, I believe, on the 25th, and I have presentations on Fridays at 8:45. So I'm just kind of looking at January 5th as a potential date and throw that out there as a starter.
I can make January 5th.
Okay. Mr. Geist, does your schedule allow on Friday, January 5th at 8:45 to have a hearing related to the proposed orders based on today's ruling?
Friday, January 5th, at what time?
8:45 a.m.
I will be there for that.
Okay, and that also will be via Zoom, so parties can participate via Zoom in that manner. All right, so we'll go ahead and schedule that. I'll double check with Madam Clerk if you have any loose ends that need to be tied up. Okay.
Pardon me.
Oh, I was just asking the clerk if she had any loose ends that need to be tied up. Hearing none, Ms. Bliss.
Again, don't want to speak out of turn, but typically the clerk asks if I want my exhibits back or destroyed. So I'll say that if maybe she just couldn't get back on. I don't mind if they're destroyed, I would just ask my binder to be returned.
Okay. All right, thank you. Mr. Geis, any last points of clarification or questions?
Not necessarily. Appreciate the opportunity to work with you on this, and it's unfortunate that things have played out the way that they have, but I appreciate you in the matter.
Okay. Thank you. Good luck to all the parties. Good luck in your efforts to raise your boy. Thank you very much.
Thank you.
The next hearing was on the presentation docket, and I don't seem to have that clip. But Odyssey says that the order was signed as presented, so it doesn't sound like there was much argument.
On the Geese and Geese matter, 22-3-28508. You have parties here on this one. And you're Natasha Geese? Okay. So, did you receive the response that was filed?
No, I did not.
Okay, is Jacob Geese, I don't see, oops, maybe you got somebody. The issue in this case, when I looked through it, there was a restraining order that was entered. And then it was set to. This is off of the dissolution that was done earlier in the year, is that right?
Yes.
Okay.
Final orders were January 5th.
Right. So have you filed a petition to modify that?
So I have the paperwork. I have an appointment with Carly Bliss, who was my attorney previously handling the matter with me.
Okay.
So I was wondering if we could just leave that in place so I can get my documents together.
Well, this probably was signed in error because there needs to be a petition filed for the court to have any ability to sign a temporary order like that.
Oh, I haven't filed the modification yet.
Okay, so I wouldn't be extending this out at this point. What you need to do is get a petition filed to modify. There's a whole process you go through, but I can't just do a restraining order without a pending action.
Okay.
So I don't see him here. He did file some responses. They are in the court file. I did see them, it looks like. So at this juncture, I'll simply strike it off today, and then if because it was scheduled for today, but that is, so my concern on this was is there's no actual motion or action pending for me to do anything. Okay.
I
So,
just asked the clerks what I needed to file to keep my
Okay.
son safe at this point, because there's been a lot of issues happening, so.
Okay, well, you're still under your parenting plan. That's not being modified. So whatever that says, you need to follow that. So you may want to talk to Ms. Bliss about the process to go ahead and move forward.
Okay, I
Okay.
didn't know because it was approved, so then that way I just haven't been doing visits. The restraining order.
Well, under that order, it was approved, but that order, I'm not going to extend that order because I don't have anything pending.
Okay, so I'm not gonna, is there any issues with me
You'll need to
from
just follow
withholding
the,
the visits from before.
you'll need to follow the parenting plan
Okay,
going forward until something else is done.
okay,
Okay?
all right.
All right. On the Geese matter, 22-3, 28508. Do you have anybody here on that? Good morning. So this, is Jacob Geese here?
Yes, sir.
Good morning.
Good morning.
This is, let me just take a look at this real quick. This one looked like it had just been served on the 19th, excuse me, on the 20th, which is last Tuesday. So that's not timely service for today. So I don't. But normally it's 21 days, but I'd have to, so we could probably. I could set this out 2 weeks to the 11th. And that would also be at 9 o'clock. And we can proceed at that time.
Okay, there's actually two matters. He filed something too.
We didn't see anything for today. Do you have something else for today?
I have revisit the restraining order that is between me and my son is based off of neglect and or me putting him in harm's way. There was a restraining order signed.
I didn't realize that he didn't show up on the 31st for court. So he hasn't been showing up for visits.
I had a court hearing the week before and I got the times mixed up.
One thing I show on today. Let me see here just a second.
Yeah, he hasn't been serving me. He's been emailing me documents on any of the stuff that's been filed recently.
Okay, so just a minute here, because this show cause is that for today? Because they're not both showing up in Odyssey. It's today. Okay, so the order show cause, which was the, so that one would be, we could set that out 2 weeks. The other one, I don't know, did you serve that motion, sir?
Yes, he tried to refuse service. He had the documents in his hands twice, and he did end up with the document that had the time and date for court, and then he never showed up.
I'm talking about for the one for today. He served some
I
paper.
had to have served by the sheriff's office because he was refusing service again.
Okay.
It's not a matter of me refusing service.
All right, so it looks like you filed a notice of hearing for today. I don't have a motion attached to that. So if you're gonna want the court to look at the existing order, you need to file some sort of a motion requesting that. So I don't have a motion pending on that. I'm not sure, that may be why it's not showing up on the docket. The other one. So what I can do, I can set this out 2 weeks to the 11th at 9 o'clock to reconsider the show cause order, since that was served on the 20th.
Is that for him or for me?
That was the one you served, ma'am, or you had served. That was served on last Tuesday. So that would put it timely on the 11th.
Strike order for the consent.
Well, let's read the contempt motion, looks like.
It's for today.
I'm sorry.
So for the motion, what exactly are you, because I went and saw, I got legal advice and she said I had everything that I needed to file.
Well, you filed everything. It's just it isn't timely for today
Oh, okay, because you said there wasn't a motion attached to that. so-
on his motion.
Oh, yeah, that's what I asked and you said mine, sorry.
Right. So you've got the show cause on the contempt, and sir, you've noted a motion. You call it revisit restraining order. You need a motion with that of some sort?
I didn't realize that I needed a motion attached to it.
Yeah, so you'll need to file, if you don't agree with the existing order, and I don't even know when that was entered.
Approximately a month and a half
Is
ago.
that the one from back in July?
Should be, yes.
Yeah, so if you want to have the court reconsider that, you need to file some kind of a motion, and then we'd be happy to look at it. You need to serve her, give her the appropriate notice under the court rules, and note it back on for hearing. So that one, I don't have a motion to hear, so I can't really set that one over at this point, but I'll set the contempt motion over 2 weeks to the 11th, and that'd be at 9 o'clock as well.
All right, thank you.
In the meantime, your orders are in place and they need to be followed.
Yes.
Okay, thank you.
Okay. All right.
All right. Well, let me just touch base with, there's 2 remaining cases and we're at 12:45, and unfortunately, I think we need to end the docket at this time. So let me just touch base with Natasha Geis and Jacob Geis. Come on up, Ms. Geis. And I recognize I've asked you how to pronounce that last name in the past, and maybe you can remind me how to pronounce it. Geis. Okay. Thank you. Jacob Geis, are you on the line?
Yes, sir.
Okay, Mr. and Ms. Geis, I apologize. The docket has ran longer than anticipated. This is a motion brought by Ms. Geis for contempt. And it looks like service was proper upon Mr. Geis, and it relates to child support, daycare expenses, and the refinancing of the truck, and kind of the aftermath of all of that. So let me just double check. So we're time crunched at this point. I have another docket that starts at 1:30, and I was going to meet my daughters for lunch at 12:30, so that's may not happen today. So I just want to ask you, if we were to continue this matter to next week, if there's any undue burden in doing so. Ms. Geis.
That's fine.
Okay, I apologize. Mr. Geis.
I would just like to address the matter at a timely pace.
You'd like to address what?
The matter at a timely pace. That's all. So
Yeah, and I think if we're to address it today, there may be a sense of being rushed, and so are you comfortable with setting it over 1 week to next week, with the 18th of September?
yeah, I'll notify my employer.
Okay. And again, I apologize. I recognize it's a significant investment of your time to get here and then have the case continued. So I apologize for that. So we'll set it over to 1 week, and I'll do my best to call it early in the docket.
Okay, thank you, Your Honor.
All right, we'll see everybody then. Thanks.
Thank you.
Natasha Geis and Jacob Geis. Is it Geis or Geezy?
Guys.
Geis. I'm not even close. I'm sorry. Do we have Jacob Geis on the line?
Yes, sir.
Okay. There we go. I see you both. Okay.
Hello.
I'm sorry.
Hello.
Mr. Radcliffe's in there.
I'm Gareth Clark.
Mr. Radcliffe, apparently we have you on the wrong meeting. So if you're, I don't know which docket you're looking for, but this is the family law docket. So if you're looking for the trial assignment docket, it's a different docket. Okay. Okay. So this was your motion, ma'am, about child support, non-payment, and some other related expenses. So let me get back down to that. That is the one filed August 14th. Is that right? Okay. And I did have proper service. And sir, Mr. Geis, did you receive all those documents? It looks like they were served on October 21st
Yes, sir.
or August 20th, I'm sorry. And have I don't see anything in the court file. Had you filed anything in response or?
I've been kind of limited on my access, and no, I did not file anything in response.
Okay. So what this is a request for a contempt, it's a contempt motion. And I don't know if you had a chance to look through that. Basically says that you've not paid child support or daycare for that order to the tune of just under $4,000 and then potentially some daycare expenses.
So what that's referring to is back child support and childcare. And I have been paying everything because it comes out of my paychecks. Child support and childcare both come out of my paychecks through DCS.
Is that going to the state or how is that being paid?
I'm not exactly sure how DCS goes about it, but it comes out of my paycheck and goes to DCS and then goes to Natasha. I think they distribute it that way. They just make sure it comes out of my paycheck. Like this last pay period, approximately approximately $432 came out of this paycheck.
And you're indicating you're not receiving that, ma'am?
So what the issue is Jacob has had multiple jobs since January, and he's refusing to report those jobs, and he falls behind, and it leaves me weeks, 2 months without any child support. That's why he's so far behind. And I did file a note from the DCS enforcement officer stating that he's never reported a job since this case has been open.
Let's see here.
That's the exhibit 1.
I see that. I see a letter from, or an email, it looks like, from somebody at DSHS. Let's see here. So that's been through DCS, it looks like, since the order was entered in January, correct?
Yes.
Just a minute here, I'm just looking at that order.
Hello?
We'll be with you in a second. I'm just trying to see what under this court order, what the so, sir, I'm looking at the order. I don't see anything in here that there's a specific requirement to advise DCS what your job is, but if they do not deduct out of your check, you are required to make that payment yourself.
I understand.
And are you telling me that you've done that or you haven't done that?
I was unable to do it currently because of my job turnover, and I've been trying to catch up as much as possible. I'm without a vehicle. I'm barely making means to be able to pay my bills and feed myself. I'm honestly doing the best that I can, and it's not that I'm withholding from anybody. I just am simply doing my maximum at this current time with my resources that I have.
Well, where are you working at, sir?
I just recently got a job at USPS in Longview. In the last few months, I had a few turnovers, which were unfortunate based off of all of our circumstances in this situation, but I have been doing my best to maintain my employment so that way I can take care of myself and others, including.
Well, let me ask you this then. She's indicating that there is just under $4,000 total, it looks like, unpaid since January. Would you agree or disagree with that?
Since the orders were put in place, I agree.
Okay. How much, do you know how much has been paid?
I've only received one back payment, and that was because DCS intercepted his tax return. And that was $2,300. He's never made a voluntary back payment by himself. And then I would like you to look at Exhibit 2 because he actually offered money to the other mother of his other child. Well, I was pleading for him to at least give me $100 a week to help with childcare. And he admitted to the other mother that he was ghosting me, ignoring me on purpose, but offered her money for school pictures and clothes.
It's inaccurate that I was ghosting her this year and that I had any deliverance to make sure that one party was taken care of and not the other. The circumstances were that I couldn't take care of myself, and I told the other party that I was willing to try to do my best. That was.
I'm just looking at that other document.
Regardless to my ability to, or my suggestion of offering to help, I was only limited on what I could do anyways, and I wasn't able to help the other party either.
That's not what I was informed.
All right. Well, I didn't really have that information. I mean, there's some discussions here, but I don't have what I've got is you didn't pay support, and it's a significant amount. It's January of this year.
That's just including back child support as well, though, not current support. That was previous to the order.
He falls behind every month on current support also because DCS
well,
wasn't able to take the full amount from his checks.
Well, hold on just a second because you're looking at you. I'm just looking at your decree there. So there's nothing in your paperwork from January that indicates there was anything owed from prior to January.
There was previous child support owed before about 2,000, and since January of this year, it's raised to.
No, what I'm saying is as of January, there is nothing that indicates there was money owed at that time.
Okay.
That's what I'm saying. So is this amount that you put in your paperwork, is that from January to now?
At least half of it is.
Okay, and there's no judgment in the last order. Let me just check
I
one
don't know
thing
if it's
here.
just because DCS had.
It doesn't address anything. Yeah, so but in any event, if half of it, it's still, that's a lot. We're talking about 8 months and your child support is 500 and 40, was it 543, 534?
I also have to pay an additional 550 approximately for child support on the same.
Childcare.
And approximately more than half of my check is coming out each time. So it's not like I'm doing anything to withhold. I don't make anything more than what I'm able to provide, and I'm hardly even able to pay my bills right now. I can't, between the cost of food and everything else that's going on, my rent is more than half my paycheck. And in 1 month.
Okay. Well, here's what I don't have from you, sir. I don't have any kind of written response about any of this stuff. Okay. So my inclination today would be to make a finding of contempt. What my thought on that is that to set this out about 2 weeks, I want you to file a declaration showing me your current income and expenses so we can determine how much you're going to need to pay towards back support to purge that, in addition to making the current support payment.
Yes, sir.
So I am going to make a contempt finding. But I'm not going to enter that order today, so that'll be entered once we determine what the purge numbers are. That'll likely be Judge Evans hearing that, but we'll set it over to the 2nd of October. And so by next Wednesday, sir, I need to have you file, there's a form you can get from the clerk's office. I don't know if it's available. Is that available on the website? Can you get that, or just a financial declaration? Yeah. So if you go to the clerk's website, there's a list of forms. And basically it's a place for you to detail out your income and your expenses.
Okay.
So what I would have you do is fill that out and file that with the clerk with a copy to her.
Okay.
And you can also want to see a current wage stub.
Yes, sir.
And that would be filed separately, but under seal, because that's a financial document.
Okay.
So I need to have you do that by next Wednesday, and then we'll come back on the 2nd and then determine how much, what financial requirements you're going to have going forward.
Okay. Thank you.
Okay. All right. So I'll come back on the 2nd. You should get some documents in the mail.
Okay.
Yes, ma'am.
There is another issue with his truck.
Okay. Did I miss that? I didn't see that.
It's all together.
Just a second.
So Jacob lost his truck with the bank, and the bank sold it at auction. There's still $10,000 owed on the truck, and Jacob's completely disregarded the bank, and I'm making the payments now on that loan.
Okay. And was that let me see here. Get your decree.
Exhibit 4 is actually letters from the bank. That's attached with my declaration.
Have you, as a collection, have you had any money taken from you on that debt?
I paid last month $100 because I off-charged the account instead of refinancing the 10,000 with the bank, which would be like 215, but I couldn't afford that. So I'm making $100 payments a month. Last month was my first payment.
Okay. So I'm looking at your decree of dissolution from January 5th, sir, and that is a debt that it looks like you were required to pay.
I understand that it's a debt that is on my shoulders. I also did communicate with the bank, and they asked me if I was able to set up a payment plan, and I told them that I don't have any income to be able to support a payment plan at the moment, and that I would keep in communication with them.
If you look at the letter from the bank, as of today, he had 7/22/24, he's never communicated with the bank. I got a letter from the lady.
Okay. Well, that's not a contempt issue as much as any, but he's required to reimburse you for any costs that you have related to that.
He's not communicating with anyone on it.
Okay. Well, sir, that'll be an issue when we come back on Wednesday, because anything she has to pay on that debt, you're required to reimburse her for.
I understand.
Okay. So that'll be addressed in the order we do.
How would I go about, because I would like to have my name removed from this debt and have him take it over?
It's totally up to the bank. It's us. I don't have any way to order the bank to do that.
But would we be able to order him to get it refinanced? Because he didn't.
If the
follow
bank's
through with
willing to do that. And I don't know that he can refinance it. I mean, I don't know what is, that's what I don't have the income information to know if that's even feasible.
Okay.
He is required to reimburse you under paragraph 12 of the decree for any costs, attorney's fees, anything else that you have to pay on that debt though.
So, and that's another issue too, is he's never voluntarily paid me back for attorney fees that were awarded to me at the mediation, and I'm still making payments on it and a trial.
And that's again, that's a debt he owes to you.
Yeah,
So,
he's
collection.
not doing it.
Okay. Well, you may have to go through collection action and do some garnishment or something, but that's not a contempt issue. We're not paying under the state law, at least at this point. So, all right. So come back on October 1st, and that would be at same docket, same time. And sir, I need to have you file that by next Wednesday.
Yes, sir.
The second.
Was it the second? Second, I'm sorry. Working out my memory, which is not good. 2nd of October at 9 o'clock. Okay.
9 o'clock.
Yes. And it'd be the same docket. I'm not sure which courtroom it'll be in.
Thank you.
You're welcome.
Thank you.
Welcome.
Next, I have Natasha Geis and Jacob Geis, cause number 223-28508. All right, and I know I've asked you this in the past, the proper pronunciation of the last name. Geis. Okay, very good. Thank you. Ms. Geis is in the courtroom. I'll ask if Jacob Geis is on the phone call.
Yes, sir.
All right, I see you, Mr. Geis. Welcome to you. All right, here we're on, it looks like this is related to calculation of a purge amount related to the contempt that was found by Judge Basher related to the truck payments.
There's the truck and the back child support.
Okay. So, right, because Mr. Geis provided some pay stubs from the post office where it shows some, I think it showed some withholding for child support. Did you see those documents?
I did see the documents. I had to buy copies from the clerk.
Okay. All right. So just let's take a quick look at this and I'll hear input from both parties, please. As far as the truck, initially it showed the amount owing was $3,952. And I had a record that Mr. Geis had made 4 payments. And then we were looking at the remaining amount, and that would be the amount that would purge the contempt.
So on the truck?
Well, I'm not sure if I didn't put on my notes. Oh, no. There's an outstanding balance of 10,342 initially, and then that's when it was repossessed, right?
Yes.
And then Mr. Geis needed to refinance the truck by a date certain.
And he never did.
Okay.
And so my name's still attached to it at the bank.
Okay.
I've made 2 payments now. He won't communicate with me about making those payments or reimbursing me.
Okay.
It's $100 a month. He's never been in contact with the bank.
Okay. So you're asking then for Mr. Geis to refinance the truck, the deficiency by a date
They
certain.
won't refinance the truck for him at Red Canoe. He'd have to get a loan through a different bank
Okay.
to take over that.
Okay.
I'm just asking him to make the payments.
The $100 a month?
Yeah.
Okay.
There's a $10,000 balance on it and he's not even communicating with me about it at all.
Okay. Mr. Geis, what's your position related to that?
I have communicated with the bank about it, and I told them that I'm not in any financial disposition to be able to do anything at the time. And they told me that when I was available to be able to do something about it, that I could set up payment arrangements then. But they weren't going to set anything up until I had the means to be able to follow a payment plan.
So Ms. Geis is requesting that you pay the $100 a month payment. Is that something that you can do?
I cannot currently afford that. I can't even currently afford to financially sustain myself.
Okay. So there's a couple ways to approach this. So the contempt was found related to the non-payment. Judge Basher made that finding. And at this point, the order was that the truck needed to be refinanced or make payments on it. So I'm not sure which of those you want to do, Mr. Geis.
I attempted to refinance, and upon me trying to refinance, they also addressed that I needed a cosigner based off of my current credit, and I don't have a cosigner that gets the cosign with me, and so payment arrangements was the option. And I did communicate with the bank about payment arrangements, and they told me that if I didn't have the means to be able to set something up today, that they weren't going to worry about it. And this is when I talked to them.
That they weren't going to what?
That they weren't going to start a process.
Because I was the one that took it upon myself to charge off the account. So when it gets sent to third-party collections and I'm making the payment, so they stopped reaching out to him.
So, Mr. Geis, it seems based on the contempt and the, how we got to this point, that deficiency is your responsibility. So there's two ways to do it. Well, one, I can say that you have to refinance by a date certain, or that you take over the payments on a monthly basis.
I can understand that I would take over the payments, but I'm not currently in any disposition to be able to afford to do that. I can't afford to add anything to my plate because I already don't have anything on my plate to give. So I'm not sure exactly how to go about this better. I understand the refinancing and accepting responsibility for the truck. What I'm telling you is that I'm not arguing that. I'm just saying that I don't have any ability to do anything more than what I'm currently doing. I'm not even, go ahead, apologies.
Well, just my apologies for interrupting. Have you checked with other financial institutions other than Red Canoe, credit unions, banks? Have you checked with other finance companies? They generally charge a higher interest rate. Have you checked with them?
So I did talk to one main financial, I did talk to Credit One and other companies, and they were telling me that the loan amount, unless they have collateral, they're not willing to take on the loan without anything collateral wise.
Okay. All right. So I think what needs to happen here, when is the $100 a month payment due each day or each month?
It's just due by the end of the month and I've already made 2 payments.
Okay. So you've paid for September.
August and September.
August and September. So the next payment would be due October 31.
Yes.
Okay.
And I normally use my second paycheck of the month to just pay it and get it over with if he hasn't reached out to me.
Okay. What we're going to do is that I'm going to require Mr. Geis to make that payment by the end of each month, and we'll have a review the following Monday each month to make sure that that's been paid. So we'll set a next court hearing. That'll be on November 4th at 1 p.m. We're changing this normal Wednesday at 9 a.m. docket. As of November 1st, it's changing. It'll be Mondays at 1 p.m. So we will set it for the first Monday of every month to make sure that that payment is made. So the first review hearing will be on November 4th at 1 p.m. The second will be on December 2nd at 1 p.m. and so on. January 6th at 1 p.m., February 3rd, 1 p.m. And if you make that payment, Mr. Geis, prior to the review date, that you wouldn't and provide proof to Ms. Geis or the court or both, then you wouldn't need to be here. If you have not made the payment, then you would need to be here to explain why, and we would discuss potential ramifications or consequences for non-payment.
I understand the perspective of the ruling, and I want to just elaborate one more time that I'm not currently in any financial disposition to be able to afford $100 a month additional on top of what my current outgoing is. Based off of my pay stubs as seen, you can see that I only make at maximum probably $1,200 a month. This last paycheck in a 2-week period, I got to $340 after child support was paid. That was what my take home was. My rent is $800 a month, and there is other additional expenses, food, electricity, and so on. And so for me, on a $1,200 a month basis, I can't afford $100. I can barely get by as it is. I'm doing the best that I can and going to food banks just to be able to survive at the moment.
Have you taken a second job?
I can't take a second job with my current employment situation because with the post office, I'm more or less on an on-call basis, and I don't have a vehicle at the time. I had to turn in my truck, and so I've looked into possibly getting another job in the evenings after I would be working at the post office, but I don't have means of transportation at the moment. I would be more than grateful to be able to do that.
Your Honor, I'd like to state that he has a girlfriend that lets him have access to her vehicle, and I'm pretty sure she's living with him. So, I mean, that should be someone at least helping him with his house bills.
Okay. I'm just writing a bench order, one moment. All right. So from what it sounds like, Mr. Geis is an able-bodied individual that has the ability to work a second job. And just for an example, I have friends who are fairly low income. They both have regular jobs and they both took on separate jobs and they work in the evenings. And so they're working about 16 hours a day to make ends meet and because they had some new expenses that they had to cover. They're weary, they're tired, but they're making it happen. Mr. Geis will need to step up to the plate and pay the $100 per month. So the first payment is due no later than October 31st. You'll need to provide proof of payment to both Ms. Geis and to the court. We will review that on November 4th at 1 o'clock in the afternoon to make sure that payment has been made. And then we'll review that on the first Monday of each month at 1 p.m. to make sure that $100 payment has been made. If the payment has not been made, then the court does retain contempt powers. So just be advised. So I've signed that order. Then the next item to address is the child support. Mr. Geis, you submitted some pay stubs, and I want to ask you about those because I wasn't quite sure how to read those. They're not the most self-explanatory documents. In the first payment paycheck, I showed, it looks like it said CS, and there's two lines that have CS on it, which I'm assuming is child support, and you can help me clarify if that's incorrect. The first one showed $362, and then another withholding of $233. And that's in reference to the pay period number 1624. So it shows CS/SS, and it shows, is that $362.40? Is that child support that's withheld?
That's one portion of child support, and then I have another child support case, and the $133.94 is going to the other child support case.
Okay, so the 362 pertains to this case.
Yes, sir.
Okay, and then looking at pay period number 17, $414, that there's a payment there that's going out in this case. And so, and then I see two other statements, the pay period 18 and 19, where it's respectively 432 and 461. What are those pay periods? What are the date ranges for those? I didn't see that.
The date ranges.
So for example,
I get paid every 2 weeks.
Okay. So pay period 16, what would be the corresponding dates related to that?
One moment, please. Pay period 16. So I just got paid on the 27th. And that was pay period 20th. 19.
Yeah, so maybe you can tell me what pay period 19 would be.
19 would have been the 13th of September.
So that's the pay period ending September 13.
Yeah, that would be, the day I got paid was on the 13th. So I think the pay period probably would have ended that Sunday, September 8th.
Okay. So that's
because they would have the week of for the 9th to the 13th to do payroll.
Processing
I believe.
Okay. So that's showing that withholding's occurring, at least going back, if September 8th is the most recent stub that you're showing, then we would go back 2 weeks. to August 26th, roughly 25th in 2 weeks. So sometime it looks like maybe in July, and there's payments in July, August, and September. Correct?
I would. Yes, I would.
Because there's 4 payments, and that would
Yes.
wait to 2 months roughly.
I believe that would be accurate.
Okay.
I believe I started working for the post office in July.
Okay. This guy's.
I don't have a.
Go ahead.
I apologize. I don't have a day exactly that I started. When I started with the post office, the application date is actually my starting date, but my days worked didn't start the day that I got hired onto the post office.
Okay.
So I don't know exactly sure.
So Ms. Geis, as far as the child support, it looks like there's been withholding. Have you received any child support from Division of Child Support?
I have received the child support. The issue that I've been having is he's had 5 jobs since January. And per the child support order, he's supposed to report those jobs. He doesn't. So he falls weeks to not months behind. That's why he's over 4,000 behind at this point.
Mhm. Okay. And I think this is where I led off when we were talking about the purge amount for I showed that there was about $3,952 of back child support that was owed. And then we were talking
over
about
that now at this point, though.
Right.
So
So we were talking about a purge amount. So we're trying to calculate if he were to pay, looks like he's paid 362 plus 414 plus 432 and 461, which would be reduced from that original amount. Of course, this is based on the date, the
just
amount
the
of the
numbers that you have in
pleadings.
front of you, yeah.
Yeah. So I think we would reduce that 3,952 by those 4 payments, and that would give us the amount that would be the purge amount, which would allow Mr. Geis to purge the contempt if he pays the remainder of that amount.
Okay, what's the remaining?
So let me ask my friendly calculator here to make sure I do this correctly, and I'll speak it out loud so you can all follow along. So I have 3,952, and I'm subtracting from 3,952, subtracting from that the first payment of $362, subtract 414, subtract 432, subtract 461 is a purge amount of $2,283. So any questions on that calculation, Mr. Geis?
No questions on the calculation.
Okay. So I'll include here on this order is that the contempt was found on September 18th for failure to pay child support. And then I'll just state that the purge amount to purge the contempt is payment of $2,283.
Okay.
So
I'm curious to what's the comprehension of my ability to be able to pay that, and what time frame even, because I understand the perspective to the situation, but what's the end goal in this? So that way I don't get to see my kids and I'm in jail. Like, I don't understand. I don't have money.
So the purging a contempt comes into play. There's certain aspects. If a person has been found in contempt a certain number of times, then that can have an impact at a final parenting plan hearing as far as the amount of time that a parent has. It can have some negative impacts. So when a person purges a contempt, that purge goes away and is basically kind of off the records. It doesn't count against you when we have a final hearing. So that provides some incentive for people to purge the contempt because it erases that black mark, if you will.
I appreciate your explanation, and I just want to make sure that's understood that at this current time, I don't even have the ability to be able to see Ezekiel because there's currently still a restraining order in effect, because it was approved that there was a temporary restraining order because when I took him down to the river, apparently when I brought him back, he had heat exhaustion, which ruled for a restraining order, which it wasn't necessary. And I have multiple people's testimonies to me taking care of my child and everybody being aware of everything going on around us. And you know, it's been several months at this point in time since I've had to see Ezekiel, and I just don't understand, you know, like I already don't get my children, and I don't have the money to be able to survive.
Your Honor, I have told him that the restraining order was dropped, and I've tried to reach out to him for visits. He refuses to communicate with me.
Okay.
I wanted to hear it from the courts, and I wanted to see proof that I was going to not get a restraining order charge because I showed up to her house.
Judge Basher told him the restraining order was dropped.
Was
I
that
did not.
was that at the most recent hearing on September 18th? That's where the contempt
No,
hearing.
it was one previous to that.
Okay, September 11th. I was on the bench. September 18th. Let me look and see if there's
It might have been the last one. We've been here a couple of times now over this, so I'm trying to keep up.
So usually with restraining orders, they will expire on their own terms. There'll be a termination date and that'll expire on their own terms. So let me just look and see if I can find. And okay, and what's the 93? Thank you. Okay, so I'm looking at a July 10th order. It's an immediate restraining order and hearing notice filed on July 10th. And it restrains Mr. Geis, pardon me, and it restrains him from having contact with Ezekiel. And there's some distance restrictions and
Judge Basher said I didn't have the right motion, so he couldn't sign it, and I didn't know what to do at that point.
so that was a temporary order and it set a date for July 31st.
Judge Basher says that there was no basis to extend the restraining order.
So on July 31st, that restraining order that was initially entered on July 10th indicated the following. Court responds, no basis to extend the restraining order. Court struck the matter. So by virtue of the order from July 10th itself, it expired on July 31st.
I appreciate that. I was unaware of the circumstances, and I would love to be able to be in my child's life.
Okay.
I've been offering him visits. The one issue is he works weekends and he won't share his schedule with me to get a visit during the week.
I have most Wednesdays.
Oh, hold on one second. Oh, I apologize. It looks like our recording system had a hiccup, so we just need to restart the recording system. Sorry. Okay, once we get back on the record, going back to the purge, I just want to share with you what I wrote as far as the order. It says contempt was found on September 18, 2024 for failure of respondent to pay child support. To purge the contempt, respondent shall pay $2,283. So I signed off on that. Issues related to communication and the parenting plan, those are not docketed for today, so we're not going to explore those very much. It sounds like the parties are having difficulty communicating. You might consider utilizing a service. Our Family Wizard is one. It's an app. It's a third-party app that records all communications between parties. It allows for exchange of documents. It allows for exchange of a mutual calendar that promotes parties that are having difficulty communicating to communicate for the benefit of the child being able to spend time with both parents. So that's one option.
So I've offered this before and he can't afford it. So that's why we haven't been able to do it.
Okay.
The expression to the situation was that I was willing to participate in that, but then the other party told me that I had to pay for her part in it as well if I wanted to communicate with her on that basis.
No.
So it sounds like if you both chip in your respective amounts, that might be a good idea. And Ms. Geis is indicating that she's willing to pay her half if you pay your half.
I understand.
Okay, so I've signed off on those two orders related to the child support purge contempt amount, and then also related to the $100 a month payment obligation and the continuing, what we call it a pay or a peer docket, Mr. Geis. And so if on November 4th, if you know you have paid and you filed proof of payment with the court prior to that date, then you wouldn't need to be here on the 4th. If you have not paid, then you'd need to be here on the 4th of November to explain why.
I understand.
All right, so that'll conclude the hearing for today. Ms. Geis, do you have any final items or clarifying questions?
No.
Mr. Geis, any clarifying questions or final items?
No, I feel like that I've said what I had to say.
Okay, thank you, Mr. Geis. That'll conclude the hearing.
Thank you.
Unfortunately, that was the final hearing in my archive before the courtroom returned to in-person hearings, but there was a bit more information about the case in Odyssey. We can see that at the beginning of November, that his first appearance on the pay or appear docket was continued 2 weeks, but it doesn't say why. Then the hearing 2 weeks later was stricken because Dad did not appear. My guess is because Dad knew he had still not paid, so he was trying to do anything he could to delay the repercussions. At the next pay or appear docket, Dad was appointed an attorney for a potential jail sanction, so you know that means he still hadn't made any payments. 2 weeks later, they had the contempt hearing, where I assume his court-appointed lawyer, Savannah Rose Williams, was present to advise him. He was ordered to appear in person, and I think the reason why is because he was threatened with jail, so he wasn't allowed to ask for an exemption to appear by Zoom. But I think the reason he wasn't sent to jail this hearing was because he claimed he'd actually made a payment, so they gave him the opportunity to submit proof at the next hearing. And Dad appears to have submitted proof that he made 2 different payments on the truck. One payment that had been made 3 days before the last hearing, so he was in compliance last time, and one payment just in time to be compliant for January's hearing. Dad was also in compliance at the February hearing, and they already have the March and April hearings scheduled, so they plan to keep monitoring these payments for a while. I can't say I blame the courts at this point, as Dad seems to be either incapable or unwilling to be financially responsible, and it's hard not to see a lot of his problems as a direct consequence of his choices, such as quitting his high-paying job for rather suspicious reasons. I hope he can dig himself out of the financial hole he's gotten himself into, and I hope he starts putting more into his parenting relationship with his child outside of his financial contributions. I wish we'd been able to hear more of the details of why there'd been a TRO for neglect before the end. It concerns me that Dad may be unfamiliar with the limitations of such small children, and I hope that nothing like that incident happens again. I'll check back in with Odyssey in 6 months to see where this case is at, and I'll update if I can make any sense of it. See you next time.